Good afternoon and welcome to this demonstration of a U.S.-style jury trial. My name is John Quinn, and I am the Quinn of Quinn Emanuel. I was there at the beginning. I'm based in Los Angeles, and it's my pleasure to be here and to participate in this exercise. I think American jury trials are something that strike fear in the hearts of business people and lawyers around the world outside the U.S. There's this concept out there that it's like a lottery or a Las Vegas-style gamble and an arbitrary process. And we hope to show you today that really isn't so, that it's a different way of trying cases. But there are very strict and tight rules that govern the process. And if you talk to judges in America, they will tell you that almost all the time they agree with the result that the jury reaches. It's very powerful, the power of the jury, and to have a group of people who get together and afterwards deliberate and talk about the evidence that they have heard and reach agreement on a conclusion is a very powerful way we have found of resolving disputes. Before you get to the point in a civil lawsuit in the U.S., before you get to this point, the start of trial, the case will have gone on for generally somewhere between 6 months to 2 years in most jurisdictions. That's about how long it takes to get to trial. And what happens during most of that time period is occupied with what we call discovery, what the British call disclosure. And we have probably the most, for better or for worse, the most extensive disclosure and discovery regime in the world. And that not only are the parties required to exchange documents, but we have the ability to actually take testimony from our adversaries' witnesses and from third parties to send out a deposition notice, require them to come to our office where they be placed under oath, and we can ask them questions to find out what their account is, what their position is, what they would say. So there really is, by the time you get to trial, there is a lot of disclosure, and the parties will know a lot about each other's positions. And as a result of that, the disclosure really permits parties to handicap their chances of success, which side has the stronger case. And that promotes a lot of settlements. It's really very, very rare for a case to actually get to this point where you have a trial. And that's because of the disclosure process. The weak cases are tossed out by the court, or there's a settlement that is reached. It's really only cases like this, which are close cases, where there are real disputes in the evidence, that the cases actually get to trial. So that would have gone on before we got to this point. That pretrial process would have lasted maybe, as I say, in most jurisdictions, somewhere between 6 months and 2 years. These folks are the jury. Now the jurors, they're not like volunteers. They get a notice in the mail. Names are pulled from it depends on the jurisdiction. In Los Angeles, where I'm from, they pull names from voter registration lists, driver's license lists, and property ownership records. I get one of these notices every 18 months. Lawyers are not excused. You have to show up. They pay for your parking, and I think they give you $20 a day or something like that. So this is not something that these folks want to do. I mean, they're told, if you don't show up, it'll be like a $1,000 fine, and we'll send the sheriff out to get you. Now, as a practical matter, that really doesn't happen, but people do grudgingly show up. And the interesting thing is, none of the jurors at the beginning, they don't want to be there, and there is a jury selection process that we could talk about afterwards, which, there's an effort to eliminate people who might have an interest in the case For example, somebody who was employed by one of the parties or knows one of the witnesses or has some potential bias, they would be excused. The judge would ask the potential jurors, depending upon the court, the lawyers might have an opportunity to question the jurors briefly to try to ferret out potential bias. But by the time the jurors are actually chosen and seated, they surprisingly start to take their job very, very seriously. You often notice on the second day of trial, they dress better. Seriously, they dress up. And they want to reach a right result. It's not something, even though they're there involuntarily, it's something that jurors typically take very, very seriously. And the judge, I'm playing the role of the judge today. In the US, we don't have a separate occupation and profession that people are trained for to be judges. I mean, the judges are typically people who were lawyers. A lot of them work for the government. They might have been prosecutors. They might have been public defenders. They might have been in private practice in law firms, and maybe they got burned out. Maybe they decided they didn't really like being lawyers. Maybe they wanted to do some public service, so they end up being judges. Typically, you're appointed. In California, you're appointed by the governor, but then you have to stand for election, every 6 years or something like that, I think, Steve? Federal judges, we have two legal systems, judicial systems. We have the state system, then the federal United States judiciary. They are nominated by the president and confirmed by the Senate of the United States. That's a lifetime appointment. So judges who get that job are fiercely independent. They think, and they do, have the power to do just about anything subject to the Court of Appeals correcting them. So the judge hasn't had the professional occupational training and background that you have in your country and exists in many countries. It's typically somebody who at some point was a lawyer. And then the process of the case, once the jury's been seated, the judge will give the jury a brief statement about what the case is about. And that's a statement that the parties have agreed on, that this is what the jury's going to be told, just by way of introduction. And then the lawyers each have an opportunity to give an opening statement to the jury, where they tell the jury what the evidence is going to show. The plaintiff goes first. The plaintiff goes first at every stage of the case. The plaintiff puts on their case first, calls their witnesses first, does the direct exam of the witness first, then the defense lawyer will cross-examine the witness. When the plaintiff has called all their witnesses and submitted their evidence, then the plaintiff rests their case, and then the defense puts on their case and starts to call their witnesses. Same process. The defense lawyer will do direct examinations of the defense witnesses, and the plaintiff's lawyer will do a cross-examination. Then after that, the lawyers argue the case to the jury. They each give what's called a summation or argument to the jury, whereas the opening statement is supposed to be simply a recitation of what the evidence will show, what the lawyers believe the evidence will be. It's not supposed to be argumentative. It's not supposed to talk about the law. The closing argument, the summation, the lawyers are then free to argue to the jury, to put together the facts and the law, and do their best effort to try to persuade the jury to return a verdict for their client. Then the judge instructs the jury on what the law is. This is the law that's going to guide the jury. They must follow the law as the judge gives it to them. Then the jurors will deliberate and reach a verdict. In some jurisdictions, some courts, that must be unanimous. In others, like in California State Court, you have a 12-person jury. 9 can reach a verdict. You can have a minority of 3, but if 9 people agree, you've reached a verdict. So that's kind of an overview of what the trial is and what's going to happen here today. I'm going to start out by giving that jury that brief statement of the case, which is agreed to by the parties, which is how any trial would begin after the jurors are seated. Members of the jury, we are here today for the case of Cranbrook versus Intellex. Intellex Electronics is a U.S. manufacturer of video games. Cranbrook Industries plc is a British manufacturer and distributor of leisure products. In July 2013, Intellex and Cranbrook entered into a licensing agreement that gave Cranbrook an exclusive right to distribute Intellex's video games and video game players within the European Union for a period of at least 5 years. In year 2013, all Intellex games and game players were based on its so-called smart plug technology. Pursuant to the contract, Cranbrook manufactured and distributed smart plug products beginning in 2014. In 2016, Intellex licensed its newly developed SP2 games and game players to Contendo Gazelle NV, a Dutch company, with a well-developed distribution network within the EU for games and toys. The SP2 equipment utilizes technology completely distinct from smart plug. In the last 2 years, CNG NVs, that's to say the Dutch company, Contendo Gazelle's SP2 games have virtually captured the European market for video games. Cranbrook has sued Intellex, claiming that Intellex violated their agreement when it licensed the SP2 technology to CGNV. Cranbrook claims that its agreement with Intellex included the right to distribute all Intellex-developed video products, including SP2, and that agreement included a renewable 5-year term. Cranbrook further claims that its contract with Intellex included a right of first refusal for new products, and that it exercised its right of first refusal for SP2. Intellex denies that it breached the contract. It is Intellex's position that the original agreement covered only the smart plug technology and that SP2 is a new and different product. Intellex argues that Cranbrook's performance for the first 5 years of the contract was so disappointing that it was not entitled to renewal for a second 5 years. Cranbrook is represented by Manisha Sheth. Intellex is represented by Steve Madison. The lawyers for the parties will now each have an opportunity to give an opening statement. I caution you that what the lawyers say is not evidence. The opening statement is merely an opportunity for the lawyers to explain to you what they expect the evidence in the case to be. After opening statements, the lawyers for each side will present their evidence, and then they will each present closing argument to you. At that point, I will give you instructions of law to guide you in deliberating and reaching a verdict. I decide the law that applies to the case, but you decide the facts and apply those facts to the law as I instruct you. You may take notes anytime you wish, but I caution you not to make up your mind about the case until all the evidence is in, that I have instructed you on the law, and you have deliberated with your fellow jurors. So, Plaintiff's Counsel, Ms. Sheth, do you care to give an opening statement on behalf of Plaintiff Cranbrook to the jury? Proceed.
Good afternoon, ladies and gentlemen of the jury. This is a case about broken promises. My name is Manisha Sheth, and it is my privilege and honor to represent Cranbrook Industries. Cranbrook, you will hear, was a family-owned business that had made and sold all sorts of toys in the United Kingdom. You will hear from Blair Nichols, who is seated right here, who is the CEO of Cranbrook. He will tell you how his grandfather started this company from scratch. And he will tell you that after he got his MBA from Cambridge University, he thought to himself, I should bring my grandfather's company into the 21st century, and I should enter the market for toys of the 21st century, computer and video games. And to do that, Cranbrook entered into a contract with the defendant, Intellex. Intellex was an American gaming company, and they manufactured video games and game players that used a new computer chip called Smart Plug. This new product allowed games to operate at faster speeds and was a great tool for American-styled action games. Under the terms of the contract, Intellex developed the Smart Plug technology and licensed the name Smart Plug to Cranbrook so that Cranbrook had the exclusive right to manufacture and market all Smart Plug products in Europe. Now, you're going to see the contract in this case, and you will see that it defines the term Smart Plug to include three things. One, products that are based on the Smart Plug technology. Two, products that are designed to be used with the Smart Plug technology. And three, all modifications, adjustments, and improvements on the Smart Plug technology. Now, you're going to hear from Blair Nichols about why it was so important for him to have this exclusive license that covered not only the Smart Plug product, but also improvements and subsequent products that built on Smart Plug. And you're going to hear that he also wanted a belt and braces approach, and so he also required a right of first refusal. What is a right of first refusal? Well, on the screen, we have put up the definition. It is an option to match or exceed the terms of a competitor's proposal. And you're going to hear that he emphasized these two things, the exclusive license and the right of first refusal, to his lead negotiator, a woman by the name of Miss Eve Rosenberg. Now, you're also going to hear from witnesses from Intellex, and you're going to hear that at the same time that they were negotiating with Cranbrook, they were actively developing another product, and this product was the SP2 product. This SP2 product was supposed to revolutionize the gaming industry because not only could it support fast-paced American-style action games, but it also could support complex thinking games that were much in demand by the consumers in Europe. And you're going to hear that this SP2 product was based on Smart Plug. And you're going to hear that it was built off of Smart Plug, and that it could be used with Smart Plug games and Smart Plug video consoles so that all the Smart Plug products could be used with the SP2 technology. But in spite of all of this, nobody at Intellex breathed a word about SP2 to Cranbrook. Instead, the Intellex CEO, Mr. Ken Morganfield, knew that the SP2 product had so much potential that he did not want to be locked into an agreement with Cranbrook to market the SP2 product. And he specifically instructed his lead negotiator, a woman by the name of Willa Judson, to make sure that the SP2 product was carved out of the scope of the exclusive license. And you're going to hear from Miss Judson herself, and she's going to tell you she didn't carve out the SP2 product. Instead, she assured Cranbrook that the license would cover Smart Plug, and I quote, any plug, or any other product that Intellex had on the horizon. And nowhere in the licensing agreement did she include a carve-out for SP2. Then you're going to hear that in 2015, the SP2 product was launched in the United States and was a huge success. And Intellex wanted to expand this into Europe. And you're going to hear that when the Cranbrook CEO heard about this, he immediately sent a congratulatory email to the CEO of Intellex. And he thought, well, I'll have a naturally I'll have a right to market this product either under the exclusive license or under my right of first refusal. But you're going to hear that the Intellex CEO did not want Cranbrook to market the SP2 product at any cost. And so he took the position that SP2 was not an improvement of Smart Plug, And he also undertook a series of efforts to make sure that Cranbrook was not given the opportunity to exercise its right of first refusal. And what he did will shock you. He orchestrated a proposal with another company, a company that the judge referred to as CGNV, also known as Contendo. And unbeknownst to Cranbrook, Intellex, Mr. Morgenfeld, commenced secret discussions with Contendo to distribute the SP2 product. He told Contendo about Cranbrook's right of first refusal, and he told them, let's come up with a proposal that they will not be able to match. And you know what they did? They put together a proposal that included requirements to have repair facilities in 3 Eastern European countries, Poland, Hungary, and the Czech Republic. Countries where Contendo had sales offices, but Cranbrook did not. And he also included a liquidated damages provision, so that in the event that Contendo did not open up these repair facilities, it would have to pay $50,000 per month for each month that they did not open up these repair facilities. And then to make matters worse, it had a secret side deal with Intellex. And in that side deal, they agreed, the two, Intellex and Contendo agreed that instead of having these repair facilities, what they could do was simply mail in the repairs to a place in The Hague. And nowhere in any document you're going to see that that was disclosed to Cranbrook. So Intellex never notified Cranbrook of the actual and true terms of the deal. And you're going to hear that Cranbrook, despite all of that, matched and exceeded Intellex's offer. They accepted it, and they exceeded it by proposing that they would pay a higher percentage in royalties to Intellex. They offered to pay 18% instead of 15%. Second, they offered to produce the products on a much quicker time frame, October 2016 instead of January 2017. And they agreed to make the repairs in a centrally located office in Germany. And they matched the proposal in that regard. And what happened next? Intellex refused to accept their offer, and they waited until the end of the 30-day period to let Cranbrook know. And they basically denied Cranbrook of the opportunity to exercise its right of first refusal. Now, in an effort to get out of their obligations under the contract, you're going to hear that Intellex say that Cranbrook did not perform its obligations under the contract. But you're going to see the contract, and you're going to see what it requires and what it doesn't require. And you're going to see that all it requires is that Cranbrook exercise best efforts and that Cranbrook's performance be satisfactory. It doesn't require a specific timeline for achieving sales in Europe. It doesn't require a particular volume of sales. And you're going to hear that Intellex themselves thought that Cranbrook's performance was satisfactory. And in fact, they thought it was so satisfactory that they renewed the contract with Cranbrook for another 5 years. I'll ask you to listen to the evidence carefully, look at the documents we submit into evidence, and the evidence will show you that Intellex breached its obligation to Cranbrook in 2 ways. First, by breaching the promise of the exclusive license, and second, by depriving Cranbrook of the right of its first refusal. Thank you.
Thank you, Ms. Sheth. Mr. Madison, opening statement for the defense.
May I proceed, Your Honor?
Yes.
Good morning again, ladies and gentlemen. I want to reintroduce myself. His Honor introduced me, but my name's Steve Madison, and I'm a lawyer. And in this case, I speak for Intellex, the company that's been sued by the plaintiff, Cranbrook. And I want to introduce right at the top the 2 principals in Intellex. To my furthest right is Mr. Ken Morgenfeld. He's the founder, CEO, and he will testify in this case. He's the inventor of all the technology that we'll talk about. Could you stand, please? Thank you. And then to his left, to my right, is the individual who was the director of operations for Intellex, and this is Willa Judson. Could you stand, Ms. Judson? Thank you. And she negotiated the agreement that's at issue here with Cranbrook. Now, you know, there used to be a guy on the radio in the United States named Paul Harvey, and he would start every one of his broadcasts by saying, "Now for the rest of the story." And I feel a little bit like that here, having heard Ms. Sheth describe the case, and I want to cover some things that she chose not to cover. And first of all, I want to point out that there are some important things that are not at issue in this case. They're not disputed. First, there's no dispute that the two technologies that are at issue here, SmartPlug and SP2, were created and owned by Intellex, not Cranbrook. So Mr. Morganfield invented these technologies. He patented them. You're going to hear that there are separate patents for the two different technologies, and they are the owner. We're talking about a license agreement here. Secondly, and I'll be mindful of His Honor's admonition to not argue the law, but it is important to note at the outset, as you listen to the evidence in the case, Ms. Sheth and Cranbrook have the burden of proof in this case. She has to persuade you that the claims are valid and that she's met all the elements.
Again, counsel, this is argument. Will you just please
Yes, Your
limit
Honor.
your comments to what you believe the evidence will show?
Yes, Your Honor. And the evidence will also show that there's no dispute that the license agreement called for marketing and sales throughout Europe. Yet Cranbrook did not use its best efforts to sell throughout Europe, as the contract clearly required, and therefore we'll show you evidence that in 1/3 of the countries by population, not a single unit was sold as a result of anything that Cranbrook did or anything else. So as you consider the evidence about this right of first refusal and the breach of contract claim, remember that the broken promises that Ms. Sheth talked about, we actually agree with that. It was Cranbrook that broke the promises, not Intellex. And let me explain what I mean by that. So we should start at the beginning. In 2010, Mr. Morganfield founded Intellex. And he's an entrepreneur. He's the one who took the risk to form his own company, and risk and reward. If the company did well, he would do well. If not, he would not do well. In 2011, the company introduced SmartPlug technology in the United States, and it caught on like wildfire, went through the roof. Enormous sales in the United States. It's an action-packed game that gamers and teenagers especially really enjoy playing. And if any of you has children who play too many video games like my two sons, I apologize, and I hope you won't hold that against either of the parties in this case. So as the SmartPlug technology was rising to the top of the American video game market, Intellex naturally thought about the markets elsewhere. And the world's getting so small now with globalization, and the kids can play these video games with one another through the internet and with headsets, so they can be communicating. A teenager in Michigan in the United States might be playing with a teenager in Cologne here in Germany, and they can enjoy competing together in the game that way. So Mr. Morganfield set out to find a partner in Europe who could promote, sell, manufacture, and distribute the SmartPlug technology here in Europe. Obviously a vast market here in all of the countries of the EU. And something Ms. Sheth chose not to tell you is that a consultant behind the scenes was working with Cranbrook, trying to help prop up Cranbrook's failing business. Now, I believe it was mentioned that Cranbrook has been around for 100 years, but they are a British toy company. They manufacture wooden yo-yos and tin whistles, the old-fashioned kinds of toys that kids used to play with more. They're not a video game or tech company. And unbeknownst to Mr. Morganfield and Ms. Judson and to Intellect, this consultant named AMR went to Cranbrook and said, look, we can help you survive. You need to get into the video game market. And there's this company called Intellect that's going to be looking for a European partner. But there's a problem. They want from their European partner a company that can promote across the continent and that has a presence across the continent, has experience across the entire EU. And Cranbrook didn't have that, so AMR, the consultant, had a solution to that, and that solution was Eve Rosenberg. They suggested that Cranbrook hire Eve Rosenberg to be the individual responsible for promoting smart plug technology if Cranbrook were fortunate enough to get the license agreement from Intellect. It worked. Out of 3 potential partners, Intellect chose Cranbrook based largely, almost exclusively, on their impression of Ms. Rosenberg and her ability to market. You'll hear she speaks 3 or 4 languages. She's from the continent. She was raised in Belgium. And so this British company, which you'll hear was very Anglo-centric, had this new employee, the director of marketing, that Cranbrook believed could promote the product. And I wanted to show you a couple of the documents that are in evidence in the case and that you'll hear about. So in early 2013, Ms. Judson, on behalf of Intellect, and Ms. Rosenberg were negotiating this license agreement that's at issue here. And this is a letter to Ms. Rosenberg in March of 2013. And in the letter, Ms. Judson calls out very specifically, if you look at the last 2 sentences of this paragraph, frankly, our interest in Cranbrook is largely predicated on your representation that you are already capable of distribution all across Europe. If this is not the case, please notify us at once and we will seek a different licensee. Well, you will hear, ladies and gentlemen, that it wasn't the case. They were not already capable. They had hired Ms. Rosenberg and they hoped to be able to market and make sales in Europe, but they could not truthfully make this representation to Intellect. So the negotiations proceeded, and in July of 2013, the license agreement was executed. And you can see here Ms. Judson on behalf of Intellect and Ms. Rosenberg on behalf of Cranbrook. And I'll ask you in this trial to pay close attention, not to lawyers' words, not to the way either Ms. Sheth or I describe the contract, but what the contract actually says. And if you do that, you'll see some interesting things. So for one thing, time and time again, the contract points out that there has to be extensive marketing throughout Europe. They even go to the point here in the second paragraph that's expanded there. It's the United Kingdom and throughout Europe. United Kingdom is supposed to be part of Europe, but they were making clear back in 2013, before all this talk of Brexit and all, they were making clear that it had to cover the UK, where Cranbrook was from, and all of Europe. Now, this is also a paragraph that I want you to pay close attention to. This is the so-called right of first refusal. And you notice that it applies to any new leisure product that Intellect might bring to market and intend to promote and sell. And you'll see the evidence will show that this new SP2 technology is a new product. It is not based on the smart plug technology. It's completely different chip, completely different patents, completely different generation of video games. And so the interesting thing that you'll hear is the parties both had in mind that they could define a whole set of products out there for which the license would not cover, but that Cranbrook would have a right of first refusal for. And by the way, here's another reference on that page to Europe. They actually go so far as to call out the different regions of Europe, so it was clear. So when you hear about this best efforts clause, it's best efforts throughout all of these regions in Europe. So just within months of the contract being executed, the license agreement, Ms. Rosenberg wrote a memo to the other witness for Cranbrook, Mr. Nichols, and we weren't aware of this at the time, but through a process called discovery in this litigation, we were able to get this document. And what Ms. Rosenberg said is, now that we're set up for production, we should begin to pursue a marketing plan for sales on the continent. We're traditionally strong in the UK, but we need to build and become equally strong in the other countries in the EU. And you'll hear the evidence show that that's best efforts to market in Europe. And Ms. Rosenberg, to her credit, you'll hear, was trying to faithfully carry out the representation that she'd made. For good measure, she said at the end of the memo, I propose we devote at least 70% of our advertising budget to a multilingual campaign from the countries for the first 3 years of our contract. So, and there's another reference there at the end that you'll see. We need to start right from the continent, right from the beginning, if we want results. So Mr. Nichols' response, having now gotten this license agreement, was no, we're not going to concentrate on...
Mr. Madison, I think you're going a little over time. Can we wrap it up, please?
I will, yes, Your Honor. So you'll hear that Mr. Nichols rejected the marketing plan of Ms. Rosenberg to concentrate and decided to concentrate on the UK. And Ms. Rosenberg actually quit because of it. And this is a memo that you'll have in evidence in which she states that she can't take the Smart Plug project any further based on the British strategy. So the final thing I'll leave you with is we'll have evidence again of the Cranbrook performance on this license agreement. And you'll see that, as I mentioned earlier, fully 1/3 of the countries by population in the EU, not a single unit was sold by Cranbrook over 5 whole years. So you'll hear our position at the end of the case is that Cranbrook can't come into this courtroom not having performed the contract themselves and seek a remedy from you. At the end of the trial, I'll have a chance to come back to you and make closing argument. At that time, I'll ask you to enter a verdict in favor of Intellects on this case. Thank you.
Thank you, Mr. Madison. Ms. Sheth, would the plaintiff call her first witness, please?
Yes, Your Honor. Plaintiff calls Ms.
Ms. Rosenberg, would you please come and take the witness stand? Ms. Rosenberg, do you swear that your testimony you will give in this proceeding is the truth, the whole truth, and nothing but the truth, so help you God?
I swear, Your Honor.
You may proceed.
Thank you, Your Honor. Ms. Rosenberg, please introduce yourself to the ladies and gentlemen of the jury.
My name is Eve Rosenberg, and I'm from Brussels in Belgium.
Where do you presently work?
I'm currently the marketing director for Nederlander Chocolates, an international confectionery firm.
And can you briefly tell us about your educational background?
I was educated at the London School of Economics, and I graduated there in marketing with highest honors.
And briefly summarize your employment background.
Well, I worked for Mondemundi and Cath Kinston, both very top and trendy retailers who also sell online. So yeah, I worked there in the marketing department.
And what kind of companies were those?
Oh, those are very top sellers.
Now, are you familiar with a company called Cranbrook Industries?
Yes, I am.
And tell us how you know about that company.
I joined the firm a few years ago for 2 or 3 years.
And what kind of company is it?
Cranbrook is a British company that is engaged in the sale and distribution for leisure products in UK, but also throughout Europe. It's a small but very traditional family business. And back at that time, I was approached by a headhunter because the CEO, Blair Nichols, was looking for somebody multilingual, but also very experienced in the European market. So I initially started as a marketing representative, but was quickly promoted to the European marketing director.
And who did you report to as European Marketing Director?
I reported to CEO Blair Nichols.
Now, during your time at Cranbrook, did you come into contact with a company called Intellex?
Yes, I did.
And what kind of company was Intellex?
Well, Intellex is a huge US company that designs, develops, and markets video games, but also video game players.
Did there come a time when Cranbrook and Intellex entered into a contract with each other?
Yes, there came a time.
And what was your role on that contract?
Well, I was the lead negotiator on that deal.
Tell us about what that deal encompassed.
It was a licensing agreement between Intellex and Cranbrook, and under this agreement, Intellex licensed its smart plug products to Cranbrook. So Cranbrook would then manufacture and distribute this smart plug, SP1 smart plug technology to in Europe. And yes, so in exchange for letting Cranbrook get this benefit, Cranbrook paid Intellex a royalty.
Did you have any discussions with the CEO, Blair Nichols, about negotiating this contract?
Well, I was basically in charge, but I remember that we spoke once or twice about that deal, but I don't remember the content exactly.
Okay. Let me show you what's been admitted as Exhibit 4. Can you tell us what this document is?
Yeah, I've got a hard copy here. So that is a copy of an email written by Blair Nichols to me and relating to the Intellex contract terms dated March 19, 2013.
And what did you understand Mr. Nichols to mean when he wrote, you seem to have already obtained an exclusive license to SmartPlug along with a quite reasonable royalty. The exclusive license is really the heart of the entire matter.
Yeah, he really made clear that this exclusive license was so important for us. So we really made sure that we get this exclusive license. So we were the only ones selling and distributing this smart plug technology, and well, also distributing the latest technology on that smart plug.
And then he further writes to you, do be sure that we are protected for the extended term and that we have access to any modifications they introduce in America. What did you understand him to mean by that sentence?
So maybe the first part is protected for the extended terms. In this agreement, the parties agreed to a clause stating that they have the right to renew and to extend this contract after 5 years for another 5 years term. So yeah, that was kind of a protection for us, so we couldn't see after 5 years how everything went so far and could decide whether or not we want to enter into another 5-year term contract.
And do you recall what type of performance, what level of performance you would have in order to be eligible for another 5 years?
Yeah, I think there is a part in this contract that is saying we have to meet satisfactory substantial performance, and I guess we met because, I mean, they entered into a new contract.
Okay. And how about the second part of that sentence, that you have access to any modifications? Why was that important?
Well, it was pretty important for us to cover this modification, which meant to cover not just the smart plug itself, like this little microchip, but also the related products and modifications, like improvements of those products and also adjustments.
Now, in the next paragraph, he talks about something called a right of first refusal on their subsequent products. Do you know what a right of first refusal is?
Yeah, for us it was important to have an opportunity to include other products from Intellex. So this right of first refusal was an option for us to decide whether or not we want to adopt and distribute non-related, so not to the smart plug technology related product. And it was a protection for us in exchange for investing a considerable amount of money for setting up all this distribution system. So yeah, it was a chance to take advantage of other products from Intellex, but also it was a protection for us and maybe amortize our costs.
Now, who were you having these contractual negotiations with at Intellex?
It was Mrs. Willer-Judson.
And what, if anything, did she say to you about the scope of the exclusive license?
Well, she seemed to think that we already had this exclusive license to all products.
And in what context did that come up?
It came up when we were talking about this right of first refusal, because I was insisting on putting it into the contract, and she was just like, hey, yeah, you know, it's already covered by this exclusive license, but I wanted to make double sure that it's maybe covered by this exclusive license, but otherwise covered by this right of first refusal.
Now, let me show you what's been admitted as Exhibit 10, and let me know if you recognize this document.
Exhibit 10, yes. That is a copy of a letter written by Willer-Judson to me on April 22nd, 2013, and it's relating to the right of first refusal.
And when she writes to you, it looks like we have a deal. What did you understand her to mean?
Well, it was her answer so it was her answer to my insisting of this right of first refusal. So yeah, it looks like we have a deal. Sounds to me that, yeah, we're going to agree on that.
Okay. Now, in the next two sentences, she talks about the right of first refusal. And if you can focus on the second sentence, we look forward to seeing you market smart plug or, quote, any plug or anything else for that matter. What did you understand her to mean by that sentence?
Yeah, so she seemed to think that it's already covered by this smart plug technology. So she said smart plug, also any plug, so any other plug and anything else, it's going to be distributed by you.
And what, if anything, did she tell you about Intellex's introduction of any other products in Europe at this time?
I think nothing.
Well, if you read the next sentence, does that refresh your memory about what she told you?
Oh, yeah. We do not anticipate introducing any other products in Europe. Yeah.
Now, at any point in time during these discussions, did Ms. Judson tell you anything about a Smart 2 product?
No, she didn't.
How about something called an SP2 product?
No.
Now let me show you what's been marked as Exhibit 62. Do you recognize this document?
Yes, 62, that's our final contract signed on July 15, 2013 by Willer-Judson and me. Yes.
Now, if you take a look at paragraph 1, tell us what that is about.
Well, it shows the responsibility of Intellex for providing an exclusive license to manufacture, sell, and distribute smart plug video games and game players to Cranbrook.
And now if you turn to paragraph 11B of the contract on page 3, tell us what that paragraph is about.
So 11B, there is this, I guess, definition about what smart plug and smart plug products meant or going to mean in this agreement. And it says, not just smart plug, the microchip itself, but also other products or devices that are based on or designed to use smart plug microchip technology and extend to all modifications, revisions, and adjustments. So, yeah. pretty clear to me.
And how about the very last clause of paragraph 11B? What does that cover?
To all improvements up on that technology. So I wanted to make double sure to cover these improvements. Because we weren't really equipped to do our own research on this video game industry, so we had to rely on intellects, what the new technology is going to be in this industry. And we're a small business, so we relied on that. And otherwise, well, intellects could just pull out the rug from under us as soon as there is a new innovation. So it was important for us, and not covering this improvement would be suicidal.
Mm-hmm. Now, if I can direct your attention to paragraph 2 of the agreement on page 1, what was the time period for the license, the exclusive license?
It was 5 years.
And did you have the right to renew the license for another period of 5 years?
Yes, we.
And,
have that
sorry,
right.
go ahead.
Yes, yeah, we had that right, and it's in paragraph 7. Mm-hmm.
And in paragraph 2, what is required for you to be able to renew the license for another 5 years?
Satisfactory substantial performance of each party.
Now let's take a look at paragraphs 9 and 10. Can you tell us what are these paragraphs about?
Paragraph 9 is about this right of first refusal. So Intellects grants Cranbrook a right of first refusal. And paragraph 10 then says how we can make use of our right.
And what is the scope of the products covered by your right of first refusal?
The scope is to cover, all unrelated products that are not related to this smart plug technology. So pretty much everything.
And what did you have to do to properly exercise your right of first refusal?
We have to do our best efforts in markets and distribution. They had to make sure that we can make use of our right by being notified or, getting this opportunity to manufacture also other products.
And what would happen if another company had a proposal to market any new product?
Then it says that they have to give us written notice, and we have a period of 13 days within we can meet or exceed the terms of that proposal.
Now, did there come a point in time when you left Cranbrook Industries?
Yes, I left them.
And when was that?
It was approximately 8 months after we finalized that deal.
And why did you leave the company?
Well, I thought I couldn't take this smart plug product any further because of the insistence of the CEO and a different marketing strategy. And my parents were ill, so I decided to go back to Belgium. And by returning to Belgium, I could combine taking care of my parents and also, going on with my career.
And at the time that you left, what, if any, benefits did you get from the company?
In my severance, or part of my severance, were stock options.
Now, did there come a point in time when you learned about the SP2 product?
Yes.
When was that?
It was, probably very short after they closed that deal with this company, Contendo. And I read this article in the newspaper Games and Toys.
And what was your reaction upon reading it in the Games and Toys?
Well, I was concerned and surprised.
And why were you concerned and surprised?
Because I knew they weren't entitled to enter into such a license agreement because they were in a contract with Cranbrook.
And what did you do when you saw that article?
I think I wrote a letter, to the CEO, Blair Nichols, by saying, hey, sorry, but that's bad. And I mean, they are doing a breach of contract.
And did you receive a response from Mr. Nichols?
Yes, I did, but 4 months later. So
Let me show you what has been admitted as Exhibit 45 in this case. Do you recognize this document?
yeah, that's a copy of a letter from Blair Nichols to me relating to this testimony.
And what is your understanding of what he was asking you to do?
He asked me to testify today.
And did he tell you how to testify today?
No, not really. Well, he said we need you to say that the contract was intended to cover all improved home video game systems and so on. But yeah.
And have you altered your testimony today in any way based on his request in this letter?
No.
And did you come here voluntarily?
Yes, I did.
And why did you come here?
Well, I came all the way from Belgium to America because I can't stand such business betrayal. And this is like David versus Goliath. So intellects can't just like swap business partners whenever they want to. So yeah, I think there is a written and clear contract, and that's all that matters.
Thank you.
Okay, so before we get to the cross-examination, just a couple of comments. On direct examination, the style of questions is very different than what you'll hear on cross-examination. On direct examination, it's supposed to be, it's a friendly examination, obviously. It's their own witness, somebody they're calling to support their case. So they're supposed to be open-ended questions, not leading questions. It's sort of questions like how, what, and then what happened, what does it say, what was your understanding. On cross-examination, you'll see the questions will be very, very leading, where Mr. Madison will ask, isn't it true that? And it'll be basically be putting propositions to the witness that can simply be answered yes or no. Because the cross-examiner wants to be able to control the witness. And the cross-examiner will have control for every question that he asks. He'll have a document that he can go to impeach the witness if the witness doesn't answer the way he expects. Or also there would be deposition testimony. The witness has previously been deposed. And so if the witness says something on the witness stand at trial that's different than what the witness said in their deposition, the cross-examiner can go to that and impeach the witness. So you'll see the style of examination is very different on cross than it is on direct. You may have noticed that Ms. Sheth brought up the question of stock options and brought up this letter that her former boss wrote her, that we need you to testify. We will need you. That may have struck you as strange that she would bring that up. How did that help her case? There is a view that it's better if there's something, and Mr. Madison will try to get some mileage out of this, you'll see on cross-examination. But there is a view that just from the standpoint of persuading the jury, it's better if there's something that's not good for your case, that you broach the subject first. You bring it up first and take the sting out of it and maybe spin it in some way before the other side brings it up first, so it doesn't come like a surprise. So she brought up the stock option, so you probably thought, well, that's innocuous. That's probably got there's nothing potentially harmful there. And yeah, her boss wrote her and asked her, we need you to testify. And she asked the question, well, did that affect the substance of your testimony? So she was trying to get out in front of those issues because she knew Mr. Madison would, on his cross-examination, would get into that. So with that, Mr. Madison, do you care to cross-examine this witness?
Yes, Your Honor. I have some documents prepared, but I actually want to start with Exhibit 10, please, if we could go to that. Exhibit 10 is the last exhibit that we had. I'm sorry, go to Exhibit 45. I want to go to the letter that led to your being here today, Ms. Rosenberg. Isn't that true, that the letter put in motion a chain of events that resulted in you being here?
Sure, because I got the information that here's the testimony to do, or a trial that's going on. Yeah.
You got the information that you needed to testify here, correct?
No, I got the information that...
Excuse me, there was an objection. What was the objection? I'm going to overrule the objection. If she needs to clarify, she can.
Well, I just got the information that here's a trial going on. That's what the letter says.
There wasn't anything in the letter that you saw that you understood was a direction about what you should testify to at this trial?
Oh, yeah, there is definitely something like we need you to say, but I didn't say it. So, because I think he got kind of confused with all these improved home video games, and I didn't say that. I made clear that this exclusive license covers the smart plug and the smart plug related technology, and the right of the first refusal is this unrelated, is covering the unrelating products and technologies.
So you understand that Cranbrook is claiming two things in this lawsuit, correct? Mm-hmm. Is that
Yes,
a yes?
sorry.
So on the one hand, they're claiming that the exclusive license, the July 2013 agreement, gives them the right automatically to market SP2, correct?
Correct.
And on the other hand, they're claiming that if that's not true, they exercised a right of first refusal, and that should allow them to market SP2, right?
I guess.
And you negotiated the agreement on behalf of Cranbrook, correct?
I did.
And when you did that, you understood on behalf of Cranbrook that there were two categories for future products, correct?
Correct.
So on the one hand, anything based on smart plug technology would fall within the exclusive license, right?
Right.
And if anything else that did not, I think you said in direct, everything else that wasn't based on smart plug technology was the right of first refusal, correct?
Correct.
So let's look at what Mr. Nichols wrote to you. And just to be clear, to put this in context, when you received this letter in January of 2017, you were a stockholder in Cranbrook, right?
I was, but just to clarify, I'm not here as a stockholder. I'm here as the principal negotiator, and I can separate things.
So you had exercised an option when you resigned to receive $160,000 of Cranbrook stock, correct?
Well, I didn't decide about that. I think it was just like part of my severance.
It was part of your separation agreement that you entered into with Cranbrook, isn't that right?
Yes, but I didn't decide.
You didn't what?
I didn't decide to put in the stock options.
Well, you agreed to the separation package that had the stock options, correct?
That's correct.
And the very day that you resigned, in your memo, you exercised those stock options, correct?
Yes, I put them in action, yeah.
And you still hold that stock today, don't you?
I do.
And you knew that Cranbrook was struggling financially at the time that you left, right?
Yeah.
And so you'd agree, wouldn't you, that if Cranbrook is able to somehow prevail in this trial, you expect the value of your stock will be higher, don't you?
I don't...
Excuse me, there's an objection. What's the objection? Well, she can answer if she knows. If she knows.
Well, I guess it would be go up, but I really stopped looking on my stock options because they went up and down all the time.
Well, I'm going to sustain the objection and move to strike the answer. The witness said she was guessing. That's pure speculation.
You still own the stock.
I am,
And
again.
you know it's better for Cranbrook if they prevail in this case, right?
Sure.
Okay, so let's turn to the letter, Exhibit 45, and I want to focus on the lengthy paragraph in the middle. It says, I have discussed every aspect of this problem with counsel, and I have been advised that your testimony could be crucial. So you understood Mr. Nichols expressing the view after talking to lawyers that your testimony was crucial, right?
Right. He talked to his lawyer.
Yes, and after that, he's communicating to you that the takeaway was your testimony is crucial to this trial.
Right, because I'm the lead negotiator, so I guess that's obvious.
Well, it says it is imperative that you testify regarding the negotiations, right?
Yeah.
And then it says, Intellex seems to be claiming that the new technology of SP2 removes it from the original contract. So did you know anything about Intellex's position prior to reading that sentence?
Well, I read about this SP2 technology, as I said. Yeah, so I knew about this problem, actually.
And actually, if SP2 is new technology, as Mr. Nichols says here, it's not covered by the exclusive license, is it?
It can, I guess, so in my understanding, it can be new technology, so as an improvement. So a new technology can also be just an improvement of an old product. That's my understanding.
So he goes on to say, since we may have some trouble with our attempt to exercise the right of first refusal, do you know what he was referring to there?
No, not really.
We need you to say that the 2013 contract was intended to cover all improved home video game systems, not just modifications on the smart plug technology. So let me start at the end of that sentence. In fact, you knew that the contract only applies to modifications based on the smart plug technology when it comes to the exclusive license, right?
Right, it covers not just modifications, but also improvements and adjustments, as I said.
And that's what he was telling you to testify to, correct?
No, I think he was kind of confused. Contract was intended to cover all improved homemade game systems, not just modifications. So I think so that's irrelevant to me because improvements and modifications are both covered by the exclusive license.
So you didn't understand him telling you, we need you to say, as some direction about the substance of your testimony here, correct?
Sure. So I read that we need you to say, but it didn't alter my testimony here.
Now, one of the reasons that you left Cranbrook was your frustration with their refusal to adopt a robust marketing strategy for Europe, the continent, right?
I said my parents were ill at that time, so I had to go back to Belgium. But yeah, I was frustrated about this business strategy, but it's just like a different approach.
And in fact, before you joined Cranbrook, your understanding was the company had no one with any expertise to market or distribute products on the continent, right?
Well, I started as a marketing representative, so I was a small person before and then got promoted to a European marketing director. So yeah, I was head of this marketing department, but there were others.
Well, I'd like an answer to my question, ma'am. My question was, you understood that prior to your joining Cranbrook, there was no one at the company that had any expertise in marketing in Europe. Isn't that correct?
Well, there were persons with knowledge in marketing for sure, but I understand, or I'm understanding that I was very important to the firm because of my educational background. But I was there for 2 years, so yeah, so that was my first big or huge agreement as well.
Prior to the time that you joined Cranbrook, they suffered from a lack of real expertise in marketing outside of the UK. True or false?
I guess true.
And prior to
I
you
wasn't
joining,
at that firm at that time.
But that was your understanding when you joined, correct?
Correct.
And then it was your understanding when you joined that they had no experience in tech products, right?
I don't know exactly, but I guess.
Well, do you recall when we took your sworn deposition in this case,
Yeah.
ma'am? Could you have your transcript in front of you?
My transcript? So
Yes.
The deposition transcript?
The transcript of your prior testimony, did Ms. Sheth not provide that to you?
Oh, I've got that.
Okay, so I want to refer you to page 1, lines 32 and 33. If there's no objection, I'll read it into the record, Your Honor.
Proceed.
Excuse me, Your Honor. Prior to that time, and in my opinion only, Cranbrook suffered from a lack of real experience in marketing outside of the UK and had no experience in the sales of tech products. That was your sworn testimony in your deposition.
Oh, yeah.
Right?
Yeah. It was, yeah, it refreshed my memory.
And then the way you came to Cranbrook was through this consultant, AMR. Isn't that right?
That is correct. I was approached by the RMA, and I think they were approached by Cranbrook.
Now, I want to also refer you to your deposition at the last page, lines 24 through 26. There's no
The
objection.
last page.
I'll read that into the record.
Is there an objection?
My severance package from Cranbrook included stock options, which I have since exercised. I currently hold about $160,000 in Cranbrook stock. Certainly, my stock would be worth considerably more if Cranbrook get the contract to market SP2. That was your sworn testimony in your deposition, wasn't it, ma'am?
Right, and I've already told you that.
Well, you told us that you didn't really pay much attention to your stock because it went up and down, but in your sworn deposition, you certainly knew what it was worth.
This is just argument at this point.
Very well, Your Honor.
The jury has heard the testimony.
Let me move on then, Your Honor. If I can move to our slide presentation, please. I just have a couple of more documents that I'd like to show the witness.
Sure.
So you were here during my opening statement, and you probably saw this document. It's the communication from Eve Rosenberg to you in March 2013. And that was during the time you were negotiating with Ms. Judson about the contract, correct?
Correct.
And I want to call up the language from the paragraph that refers to the importance of the representations that you had made about the ability to market in Europe. Do you recall your representations?
Yeah.
So she wrote in the letter, frankly, our interest in Cranbrook is largely predicated on your representation that you are already capable of distribution all across Europe. If this is not the case, please notify us at once and we will seek a different licensee. Those were the representations you made.
Correct.
So Ms. Judson was accurately conveying in writing the representation you had made.
In my understanding, she made clear that I was very important to do this distribution job, but well, I did. So.
And if they suffered from a lack of expertise prior to your joining and had no experience in tech sales, you were the reason why they were already capable of distribution all across Europe, correct?
In the time of that agreement, yes.
Yeah, at that time, at the time
At
the agreement.
that time, right.
The time the agreement was formed.
Correct.
So, how many months were you with Cranbrook after the agreement was signed? This is the agreement, July 5th, 2013.
It was approximately 8 months.
And so after that time, Cranbrook returned to the status that it had had before you joined. That is, suffered from a lack of expertise in marketing in Europe and no experience in tech sales. Isn't that right?
No, I think so. I don't remember exactly, but they got a new European marketing director, Ms. Nottingham, and I think she's really competent and good in marketing.
Well, you also think that she's not well equipped to market in Europe, isn't that right?
She's not well equipped. I wouldn't say that. No, she's a competent person. So I don't know. Where's the question?
Do you recall testifying about Ms. Nottingham in your deposition, ma'am?
I do recall. Well, yep. I was talking about her in this deposition. Margaret Nottingham is her full name.
And in fact, you felt that Ms. Nottingham's ability to only speak English was a real drawback, didn't you?
Yeah, for me, it's very important to speak different languages in marketing. But I mean, I know that to be the head of the marketing in United Kingdom, it's pretty good to be an Englishman. So she's English.
So you understand there's no dispute about marketing in the UK, right?
Yes.
And in fact, you know that that's the reason Intellects renewed the agreement for Smart Plug was because there'd been some success in the UK, right?
Yes, but not just based on the UK performance.
Based on what performance then?
Based on the whole performance, because there were growth, so the numbers of sale were growing.
In Europe, in the continent?
In Europe.
Okay. So do you recall writing this memo to Mr. Nichols? This is 3 months before you resign and about 3 months after the contract was signed.
I do recall, yeah.
And this was your best effort at providing a marketing plan for Europe, correct?
Just my opinion for a good marketing strategy, yes, that's correct.
Was this your best effort?
This would be my personal best effort, but for me, best effort, well, I would define it as getting the best outcome.
Okay, but you were the person that Intellects was relying on to do the marketing in Europe, and this was your best effort, right?
Objection. Calls for a legal conclusion.
Overruled. Asking about her understanding.
So I would say when I enter into a contract with Cranbrook, so a company, the really important person for me is the CEO, and also, I mean, it's also a question of liability. So he has the say and the last call, and so it was his decision to concentrate not on my business strategy but on his own.
So you're saying that he could overrule your recommendation even though you had the expertise in Europe, not him?
Yeah, because he would held liable for it.
That's true. So here you call out some countries that you felt it was important to market in, isn't that right?
Yes.
And you actually recommended that 70% of the advertising budget be used in a multilingual campaign in Europe, correct?
Correct, but it's part of our, where is it? I'm saying it's our advertisement campaign and our budget. So yeah, I remember a conversation in this negotiation where Ms. Willa Judson told me, hey, yeah, this whole advertisement is your thing. We don't invest anything in your advertisement. Just do whatever you want.
So
that was my understanding.
You understood that if any advertising was to be done of Smart Plug technology in Europe as the exclusive licensee, you had to do it.
My firm, my company at that time.
Yes?
The company.
Yes. So then at the bottom of this memo, you actually wrote the key, let me make sure I read this correctly. That was your opinion at that time, wasn't it?
That was my opinion, correct.
And what was Mr. Nichols' reaction to this serious proposal?
He decided on taking a different approach because, I mean, that's marketing. You can ask 10 people and they will give you 100 different approaches on how to advertise and how to market things. So this is the memo from Mr. Nichols back to you where he rejected your proposal, correct? Yes, that's correct. And instead, he chose something that he refers to in the last sentence here as the British strategy, correct? Correct. So notwithstanding that the license agreement was clear in several places that the entire continent of Europe was important, he was telling you the British strategy, right? Yes, he was. So what did Ms. Judson say when you went back to her after the representations that you personally had made about marketing throughout Europe and told her that Cranbrook was going to use the British strategy instead? I don't really remember. What you don't remember is you never told her, did you, ma'am? That's correct, because at that time I So I had to notify them if I am capable of doing this distribution at the time of this agreement. And at the time of the agreement, so I was there and my experience was there too.
But your experience was being overruled by the CEO, and you chose to never tell Intellects about that, right?
I didn't choose that. I didn't choose that, sorry.
Was there any reason you couldn't tell Ms. Judson that the British strategy was the approach Cranbrook was taking?
Yeah, the reason was I wasn't part of that agreement because it says in the agreement, I don't know the exact words, but it was like Cranbrook has to manufacture, yes, has to sell and distribute, yes.
But
So
your
check.
memo to Mr. Nichols was about complying with the license agreement, right?
Yeah, those are internals, yeah.
And in fact, your reaction to this was to quit Cranbrook, wasn't it?
Yeah, because my parents were ill.
And I'm sorry about that, but you didn't mention that in your resignation memo, did you, ma'am?
Yeah, because it's personal.
Very well, but you mentioned another reason for quitting, didn't you?
Yes, I did.
Can you tell us what that reason was?
Well, I didn't say that as a real reason. I was just trying to explain my feelings in regards to the Cranbrook firm. So yes, I said I couldn't take this smart plug project any further. And yeah, you have to know I really like to concentrate on my career. So I wanted to move on.
And why couldn't you take the smart plug project any further?
Because, I mean, there was this different approach of the marketing strategy, but there was a marketing strategy.
So it was Mr. Nichols' insistence, as you said in your memo, on a British strategy that rendered you unable to take the smart plug project any further. Isn't that right?
It was one of the reasons.
Well, it's the only reason you mentioned in the memo, isn't it, ma'am?
Because the other reason is personal.
You know, Ms. Sheth will have an opportunity to ask you to explain. My question's really quite simple. The only reason for quitting that you mentioned in this memo was your inability to take smart plug further because of Mr. Nichols' insistence on a British strategy, right?
The reason I mentioned in this memo, correct.
Thank you. Now, you mentioned growth, and I'd like to just wrap up now, Your Honor, quickly, if I could, with this summary of sales. And this covers part of the time that you were there, but years afterwards. This was provided by Cranbrook. And did it surprise you when you learned that there were important countries like Italy, Spain, Portugal, and in fact, not even countries, whole regions of Europe, Eastern Europe and Scandinavia, where in 5 full years, Cranbrook never made one sale?
Yeah, that's correct, referring on your sales percentage.
That actually wasn't a surprise to you because there were no promotional or marketing efforts in those countries, right?
Correct, but you also have to see
isn't there a foundation issue here? I mean, she left, and look, it's not my job to raise objections, but I think there's an obvious issue here in terms of, you're asking her about what happened after she left?
I am, Your Honor, because she's the person that negotiated the contract.
Is there an objection to that, counsel? Yeah, I'm hearing an objection. I'm going to sustain that objection.
Very well, Your Honor. I'll take it up with Mr. Nichols.
All right, thank you.
Thank you.
Thank you very much. Thank you, ma'am. Thank you. Tough examination for the witness. She did a great job, I think, but she was dealt a difficult hand of cards here, given the documents and given her prior testimony in the deposition. So that's difficult for a witness. She chose, some of the answers were kind of non-responsive. She wasn't really answering the questions. She was pushing back and giving talky answers. We'll have to hear from the jury later how they reacted to that. A lot of times that sort of communicates to jurors if somebody won't answer the question directly or they give a narrative and they go off topic, like the witness is avoiding answering and that they conclude that an honest answer, direct answer to the question would be damaging to their case. So that's a credibility issue. Sometimes, if a witness has to give up a damaging fact, sometimes it's better just to acknowledge it and move on. Yes, that's correct. No explanation or anything. It's like the sword goes in, the sword comes out, and there's no blood, you know? But if you push, if there's resistance, you know, these jurors who have nothing to do but to sit and watch, and their mind wanders, and they think about, like any of us would, think about what's for dinner or who's going to pick up the kids from school, and their mind wanders, and they think nothing significant is going on until they see that, you know, there's conflict between the lawyer and the witness, and then they really start to pay attention. So, does the plaintiff have any other witnesses?
Yes, Your Honor. We call CEO Blair Nichols.
Mr. Nichols, I remind you that you're under oath, and if you don't tell the truth, we're going to have the bailiff throw you in jail. Do you understand that?
Yes, Your Honor.
Proceed.
Mr. Nichols, could you introduce yourself to the jury, please?
Well, I'm Blair Nichols. I'm the CEO of Cranbrook Industries.
And what kind of company is Cranbrook Industries?
Well, it's a family business. My grandfather started it in the Victorian age, and he started with wooden toys. And after the war, he extended the business to other kinds of leisure time equipment, just as hunting equipment or fishing equipment, yes.
And can you tell us briefly about your educational background?
Well, I obtained an MBA from Cambridge University.
And after graduating from Cambridge, did you work for the company, Cranbrook?
Yes, as it was actually always my dream to take over the company, and yes, I'm very happy.
And what were your objectives for the company at that time?
Well, I knew we need to have a plan to get the business into the 21st century, and in my opinion, this business included like modern leisure games, such as computer games and computer game systems.
And what did you do to ensure that Cranbrook was well positioned to enter into that new market?
Well, we are no tech guys, so I knew we needed to have a strong partner, and as I didn't have any connections in this field, we asked AMR to introduce us to a competent partner.
And what is AMR?
They are a leading business broker.
And who did AMR introduce you to?
Well, they introduced us to Intellex. This is a US-based technology firm who are really, really successful in the US market for computer games.
And what was your understanding of how Cranbrook would work with Intellex to help Cranbrook enter into the computer game market?
Well, for me it was like, on the first glance, a win-win, because we had a strong presence in the UK and Europe, and wanted to extend into the computer business, whereas Intellex had a strong presence only in the US market so far, and they seek to extend to the European market.
And who was in charge of these discussions with Intellex? Who did you put in charge?
Well, I put in charge Mrs. Eve Rosenberg.
And what directions, if any, did you give to Miss Eve Rosenberg?
Well, for us, it was quite a bold move to expand the business into a field we are not familiar with, like the tech industry. And for us, it's a very significant investment. So I wanted a protection for our investment. And the heart of the deal should be that we need exclusivity. So we don't want it to compete with other licensees, but we wanted to be the only one to have access to the Intellex technology for the European market.
And what was the scope of that exclusivity?
As I recall, the language is the license scope it covered all SP products or smart products, as well as any improvements or modifications based on the smart plug technology. So, I wanted to make it pretty sure, and I gave these directions to Eve Rosenberg. She should negotiate a bulletproof deal. I wanted just to make sure that we have the hands on the smart plug technology, and that we are not like stuck with some old technology, because I know every other year they develop new stuff, and I wanted to have always the new stuff and not to be stuck with the old generation product and competing against new generation product without having access to it.
And what did you say to Ms. Rosenberg about what should be done with regard to any new unrelated products to SmartPlug?
Well, like as a second security for us, we wanted to have a right of first refusal, like an option on any new not smart plug related technology that we could also have a license for, and especially that Intellex is not allowed to license this new technology to any third party without our consent, or without our not being able to interfere.
What do you mean by that, not being able to interfere?
Yeah, like this right of first refusal. So when they develop like a new technology and they might have like a partner for it who approaches them saying, okay, I might want to have a license with you, under the right of first refusal provision, Intellex is now or should be obliged to inform us that they are having a proposal from a third party, and then we, after notification, we have like a 30 days period to decide whether we want to match this proposal or even exceed it maybe, or if we let it go. It's like a take or leave. But without our consent, Intellex should not have been able to license out any new products.
And do you know, as you sit here today, whether those two provisions were included in the final contract with Intellex?
Yes, they are included in the contract.
Now, was there any provision about any requirement that Ms. Rosenberg work on this marketing effort in the contract?
No, there's no contractual obligation on this.
And as far as you know, did Intellex ever insist that Ms. Rosenberg continue to work on this project after the contract was signed?
No, they did not.
Now, did there come a point in time, or withdrawn, was there any point in time during the negotiations of this contract that Intellex told you about a Smart 2 product?
No, they did not.
And how about something called an SP2 product?
No.
Now, did you learn at some point in time about SP2?
Well, I read it about a journal article about it.
Let me show you what has been admitted as Exhibit 15 in this case. Do you recognize this document?
Yes. This is the article I was referring to, which was published in January 2015 in the journal called Games and Toys Weekly Clipping.
And was this the first time that you heard about the SP2 product?
Yes.
Now, if I can direct your attention to the second paragraph, how does Mr. Morganfield, the CEO of Intellex, describe this product?
Well, he cited with the statement, it picks up and improves on the process that we began with Smart Plug.
And if you look to the last paragraph of the article, how does Ms. Judson, the vice president of Intellex, describe the product?
Well, she stated, we have an excellent technical base in Smart Plug, and we intend to build it on with SP2.
And if you take a look at the very first sentence of that paragraph, what does that say?
All observers agree, however, that the SP2 chip is an outstanding modification of the Smart Plug technology.
And what did you do after you saw this article in Games and Toys?
I recall I wrote a congratulatory note to Mr. Ken Morganfield, the CEO of Intellex.
And why did you write him that note?
On the one point, I wanted to congratulate him on the improvement of his existing SP2 of the Smart Plug system, and also I wanted to touch base with regard to the license for the SP2 product.
And what do you mean by that you wanted to touch base about the license?
Well, you must see, I just learned about the new technology from the trade journal, so I didn't have any insights. But I knew that in our existing agreement, we had this double security. On the one hand, we had this clause that the exclusive license would automatically cover any modifications and improvements of DSP technology. And in the event this provision wouldn't be applicable, we had at least the right of first refusal. So I knew we have access to the new technology under the agreement, either under the one provision or under the other. And I wanted to just proceed in our business partnership.
And did you get any response from Mr. Morgenfield?
No, I did not.
Now, did there come a point in time when Intellex wrote to you purporting to offer you an opportunity to exercise your right of first refusal on SP2?
Yes, there came one, and we were really surprised and upset, actually, because obviously they had secretly negotiated another deal with this party called Contendo, and they just, sent us a notification saying, oh yeah, we have a deal proposal with Contendo, and they just said, we remind you that you have a right of first refusal, and please respond within 30 days.
Now let me show you a copy of Exhibit 30, which is admitted into evidence. Do you recognize this document?
Yes, this is the notification I just referred to.
Okay. And what was the date that Mr. Morgenfeld sent you this purported right of first refusal?
It was sent on May 19th, 2016.
And under the terms of the contract you had with Intellex, what was your deadline to respond to this proposal?
It was a 30-day deadline.
And that would take you till when?
It would be June 18.
And what was your response? Well, let's look at the last paragraph. Or I should say the 1, 2, 3, 4, the fourth paragraph here, beginning with should you determine. What was Mr. Morgenfield asking you for in this paragraph?
Yeah, they asked us right away if we don't want to waive our right of first refusal, and they even offered us $100,000 for it, so they wanted just to buy us out for a very small amount.
And what was your response to Mr. Morgenfeld's request that you waive your right of first refusal for a mere $100,000?
Well, I declined promptly, of course, and we then first reviewed the proposal and yes.
And let me show you what has been admitted as Exhibit 28 in this case. Can you tell us what that document is?
Well, this is the proposal with the proposed terms that were agreed between Intellex and Contendo.
And let's take a look at paragraphs 4 and 5 of that proposal. What were the key terms of this proposal from Contendo?
The key terms were that Contendo offered a flat royalty rate of 15% for all sales within Europe, and further they were obliged to set up repair facilities specifically in Hungary, the Czech Republic, and Poland.
And what would happen if they did not set up those repair facilities in Hungary, the Czech Republic, and Poland?
Overruled.
There was a liquidated damages provision that if they failed to do so, that they had to pay $50,000 per month.
And was there a particular point in time upon which Contendo had to set up those repair facilities?
To my knowledge, they have not until today any repair facilities in those countries.
Okay, but under the proposal, is there a time period in which they have to set those up before they have to pay liquidated damages?
No, they have to set it up immediately.
Now, did you then respond to this proposal from Contendo.
Yes, we responded to it.
And let me show you what's been marked as Exhibit 35. Do you recognize this document?
Yes, I do. This was our response.
And what was the date of your response?
It was June 3rd, 2016.
And why did you submit it on June 3rd, 2016?
Well, we had then the time to review it and wanted to return our offer as soon as possible.
And can you tell us what was the terms of your acceptance of this proposal?
Well, I know it's a bit ambiguous, so I wanted to accept all the terms of the Contendo proposal, but we also proposed some alternative, more favorable terms. In particular, we wanted to offer an earlier start of production. I recall the Contendo proposal agreed on a start in January 2017, whereas we offered to start on October 1st, 2016, so 3 months earlier. We offered the general 15% royalty rate plus for the European Eastern countries and Scandinavia, a premium of 3%, so an 18% royalty rate. And with regard to the repair facilities, we offered as an equivalent to provide repair via mail. Though this provision was really odd to me, even so when I saw the proposal from Contendo, because it's like standard practice in the computer console industry not to repair such consoles, but to just replace them. And the consumer don't care as well, as long as they have functioning consoles.
And are each of those points outlined in this letter dated June 3rd, 2016?
Yes, they are.
Now, would it surprise you to learn that Contendo and Intellex had actually agreed that Contendo could use its offices in Poland, Hungary, and the Czech Republic as pickup and drop-off points?
This surprises me indeed, Counsel.
And would it surprise you to learn that Contendo and Intellex had actually agreed that the repairs could be conducted at The Hague, as opposed to these 3 cities?
Yes, as well.
Did anyone ever tell you about such an agreement with Contendo and Intellex?
No, no one.
Now let's turn to the next exhibit. What was Intellex's response to your June 3rd letter?
Well, they responded that in their opinion, our response constituted a counteroffer, which did not match or exceed the proposal, and that they declined our counteroffer.
And let me show you Exhibit 36. Can you tell us what that document is?
It's Exhibit 36 on the screen now.
Yeah. Well, this
Thank
is
you.
this is the response letter I just referred to, in which they declined or just rejected our response, qualifying it as a counteroffer.
And what was the date of their response?
Well, it was June 18th, so they sent it on the last day of the deadline for exercising the right of first refusal after they had 2 weeks to review.
And did they explain to you why they viewed your proposal as a counteroffer as opposed to an acceptance?
Well, they referred to this odd repair clause and stated that this would be some material term for them, and that our equivalent of offering a repair service via mail would not match this term. And additionally, they objected that our response did not make any reference to the liquidated damages provisions. And well, I was really upset and shocked because I couldn't make any sense of this repair clause. And with regard to the liquidated damages, it's quite an insignificant sum regarding the whole volume of the deal and the money involved in this license agreement. So it's, well, it was for me not material to refer to it, but would have accepted it, of course.
And what did you do in response to getting this June 18th letter from Intellex?
Well, I sent a fax to Intellex and stating and clarifying that we were never intended to propose a counteroffer and that we would accept all of the provision proposed in the agreement because we were really upset to be cut off from the new technology. So we started this new business in the technology field, and it was me who chose Intellex as a partner, and they just cut us off.
And let me show you what's been marked as Exhibit 38.
This is the telefax I was just referring to.
Okay, and if we could scroll down to your comments in the fax. Can you tell us what you conveyed in the first paragraph of this document?
Well, this was just a clarification. I literally said, you misunderstood my letter of June 3rd, 2016. We exercise our right of first refusal and accept all terms contained in your proposed agreement with Contendo. We intended no counteroffer, but only sought clarification of certain provisions and to suggest reallocation of the benefits to Intellex above the level provided for in the Contendo offer.
Okay. And what was Intellex's response to this clarification in your fax?
Well, they just briefly replied that this acceptance was untimely because it was after expiration of the deadline.
Okay. Now, let's talk about your performance under the contract, Cranbrook's performance. What did you try to do to promote Intellex's product in Europe?
Well, we are a British company and we have a strong base in Britain, and my idea was that we should focus on the British market first and to concentrate our marketing efforts there, and then just to bleed over to the continent. Because, you know, a video game system is like an investment for the consumers as well. You buy a system and then you are like quite locked in. And our approach was that we want to get some meaningful market penetration in the UK, to get some more visibility in the market, and not just to splurge our marketing budget all over the continent just with very little advertising in each of the country, but rather have like a boom effect in the UK and then just spilling over. Because as Ms. Rosenberg said before, the marketing responsibility was completely left to us and to our discretion, and there were no specific terms or provisions that we should meet in order to fulfill the agreement. So it was just we should do our best efforts, and in my view, we did.
Now, Mr. Madison referred to something in the documents called a UK or a British strategy. What is that?
Well, this is a bit misleading. It was never the approach to be limited to the UK. It was just to have the focus on the UK, and then after the first year maybe just to extend the marketing budget and shift the focus to the continent. And I think when we reported our figures, we had very promising growth in sales and on the continent. But you know, I think it was in the third or fourth year of our license agreement for the SP products, we were like cut off by when Intellex granted this license to Contendo, and then we had to compete with an improved system.
And what were the smart plug sales like in the third, fourth, and fifth year of the contract?
Well, I think
Can you rephrase the question?
Can you describe the performance of the smart plug sales in years 3, 4, and 5 of the contract?
Do you understand the question?
Yes, I
You
understand.
can answer.
Well, obviously,
Let's not have any more frivolous objections like that, Counsel. You may proceed.
well, when Contendo launched the SP2 system, our sales dropped, obviously, because who wants to buy an iPhone or a PlayStation 3 when there's a PlayStation 4?
Now, during the time of this contract, what, if anything, did you do to keep Intellex informed about your sales and market penetration?
Well, we had reporting duties under our agreement and regularly reported our sales figures to Intellex.
And did Intellex ever complain to you about the sales performance or the market penetration?
No, they did not.
Did Intellex, what was your understanding of whether Intellex was happy with your performance?
Well, I thought
Overruled.
Well, I thought they were satisfied with our performance because they never said otherwise. And as it has been mentioned before, they even renewed our deal.
Now, let me show you what's been marked as Exhibit 16. Do you recognize this document?
Yes.
And what is this?
This is a letter from Intellex to the magazine Games and Toys.
And were you copied on this letter?
Yes, I was copied on this letter.
And that's at the bottom of this letter, right?
Yes, yes.
And what, in the middle paragraph, what did you read with regard to Intellex's view about Cranbrook's performance in January of 2015?
Well, they explicitly stating smart plug sales in Europe are hardly slumping. Our distributor, Cranbrook PLC, has done an outstanding job of getting the Intellex message spread across Europe.
Now, we heard a lot of questions about a particular strategy, a particular marketing strategy. Did the contract with Intellex require the use of a particular strategy with regard to marketing?
No, it was completely left to our discretion just to do best efforts.
And did the contract specify a time frame for achieving particular amounts of sales or penetration in any of the European countries?
No, it did not.
Okay, thank you, Your Honor. I have no further questions.
Cross-examination?
Mr. Nichols, you're here claiming that your firm owns an exclusive license to SP2 technology, right?
Yes.
So can we bring up Exhibit 18, please? Now, you recall this is the email that you sent to Mr. Morganfield when you first learned about SP2 technology, isn't that right?
Yes, that's correct.
And you spoke from the heart when you wrote this email, didn't you, sir?
I did.
You didn't say anything that you didn't believe was true in this email, did you, sir?
Well, to put it into context, I just learned about the new technology from the journal, so I didn't have any technical insights with regard to the technology. But, yes.
You believed what you were writing was the truth, didn't you, sir?
Well, I knew I had limited knowledge about the technology, to which extent it differs, but I just wanted to express my congratulations for this new technology development.
And what you chose to say in the email was that you hoped someday, or you looked forward to the day that Intellex would license SP2 to Cranbrook for Europe, isn't that right?
That's what I wrote there.
So you wrote in that email that you hoped to have a license to something that you now are suing and claiming you already have. Isn't that right?
Well, you can't say this is like a conclusive statement at this point. I just learned about the new technology from the magazine. I didn't have any insight if it's a modification that is covered by our improvement clause or if it's subject to the right of first refusal. In any event, I was sure that this new technology was somehow covered by our agreement, and yes.
But you agree with me, don't you, sir, that you wouldn't have to look forward to Intellect's licensing something to you if you already had a license to it, as your lawyers are claiming in this case?
Yeah, but as I said, I don't know the technical details to which extent it's just an improvement, and it's not like a conclusive statement at this point because I just didn't have the factual basis to make it.
Now, throughout the entire time of this Intellect's license agreement, your company, Cranbrook, was struggling financially, wasn't it, sir?
Yes.
Losing money financially, isn't that true, sir?
Yes, of course, because as I said, it was a huge investment for us. We had to do all the upfront investment in setting up the production plans and the distribution network for the product. And of course, it was clear that it would require on our side immense amounts of investment. That is why I seeked to have this protection for an extended term and to cover all future developments. So of course we had that the first years were not really profitable.
Well, let's look at Exhibit 24, which is a memo that you wrote to your team, isn't that right?
Right.
This is to Tory Block operations and all senior staff. So this was something you wanted all senior staff to know, right?
Yes.
And it's dated January 2016, and you're attaching the operating results for 2014 and 15. Now, the Intellect's license had been obtained in July of 2013, correct?
Correct.
So during both of these years, you already had the Intellect's license, right?
Right.
And you say, although we have cut our losses in half, we have not achieved profitability, right? So you were losing money in each of those years, correct?
Correct.
And you go on to say toward the end, you make a reference to the growth that you were experiencing, but you say this is good, but not good enough if we are to maintain our contract with Intellects.
Yes.
And what you meant by that was you needed to have capital to be able to invest to keep the promises that you had made to Intellects about marketing Smart Plug, correct?
Correct.
Now, I want to ask you about this right of first refusal. If you look at Exhibit 38, I'm sorry, Exhibit 30, excuse me. That is the notice that Mr. Morganfield gave to you and, by extension, Cranbrook, of the proposal from Contendo, correct?
Correct.
And you were asked a series of questions about repair facilities, but I want to refer you to the exact language here. If you look at Exhibit 28, that's the proposal that Mr. Morganfield was referring to in the notice of the right of first refusal, correct?
Yes, it was attached to it, yes.
Yes, and so first of all, there was an obligation under the license agreement for Intellects to provide a notice to you and an opportunity to match or exceed the offer, right?
Right.
And they complied with that provision by sending you the notice, Exhibit 30.
Well, to my understanding,
Sorry,
it
was there an objection? You're just asking for his understanding?
Yes, sir.
You can answer.
Well, according to my understanding, that what they sent to us wasn't the complete proposal because there was a side agreement between Contendo and Intellex on how to construe certain terms.
So you're not hearing court claiming that they never gave notice of the Contendo proposal, though, are you?
Well, not as agreed.
What's the objection? You can answer. Overruled.
Well, not as agreed because they had side agreements on how to construe certain provisions.
So let's look at paragraph 5 of the Contendo proposal. And you were asked a number of questions about this with regard to repair facilities, correct?
Yes.
But Contendo was actually offering more than just repair facilities, wasn't it?
What are they? Distribution and repair facilities.
Yes, sir.
Yes.
So that's more than just repair. Distribution means a mode of distributing the products in those countries, correct?
That's what distribution means, yes.
And you understood that Contendo already had facilities in Poland, the Czech Republic, and Hungary, didn't you?
I understand they had offices. I don't know what type of facilities those are.
And Cranbrook had no such offices, right?
At that time, no.
All of Cranbrook's locations are in the UK, right?
Right.
So you never offered to establish distribution facilities in these countries, did you, sir?
Well, we said we accept all the terms of the proposal.
But on the facilities, you said repair facilities would be handled by mail to The Hague. Isn't that right?
To Germany, actually.
I thought your testimony earlier was The Hague.
This was Contendo.
Okay, that was the agreement.
Side deal.
Well, you call it a side deal, but in fact, what was agreed was that while the distribution facilities were being constructed, that customers could take the game to the facilities in Poland, the Czech Republic, and Hungary and drop them off, and then they would be sent to a facility in The Hague to be repaired and returned, right?
Well, I have no deeper insight into the side deals between Contendo and Intellex, but yes, this was my understanding.
And you understand that customers sometimes prefer to go to an office and hand the item to someone and explain in person what the problem is, right?
I don't know what they prefer.
You don't know that about customers, having a company that's been in the toy business for 100 years?
Probably there are some consumers who prefer to have like a desk, and some who just want to mail it in or ship it in.
Well, they like to talk to the person and explain what the problem is rather than taking the chance on the mail, don't they?
But I think at least in the technology business, it's different. Those are two tiny, complex products that are usually just replaced. I think the consumer want to have functioning products and as soon as possible.
So will you agree, though, that at no time did you ever propose to Intellex that you would have a facility that consumers could bring their products to request and seek repair?
Well, as I said, in the end, we said we would accept all the terms as in the proposal, and we would have made our best efforts to meet them.
But you did not accept the repair facility term, did you, sir?
Well, in our first response, we offered the mail-in service as an equivalent, but as I said as I stated in my telefax afterwards, we would accept all the terms.
You mean the one that was after the 30-day period?
Yes.
Okay, and you understood there was a 30-day period to accept?
I know.
Okay. And, I mean, I don't want to argue with you about whether in-person delivery or mail is better or worse, but there's no dispute. It's different, isn't it?
Yes, it's different.
So that was a term that Contendo was offering that was different from what you were offering.
Yeah, but they had the side deal about that they had the possibility of shipping in to The Hague as well.
while their distribution and repair facilities were being built, right?
Right.
You weren't planning on building any facilities in Poland, the Czech Republic, or Hungary, were you?
Well, we didn't have the chance to reconsider because you rejected it.
You didn't have the financial wherewithal, did you, sir?
Objection. Foundation.
You can answer that.
Probably not.
Well, maybe Exhibit 33 will refresh your recollection about this. This is a memo rather, that your head of operations, Tori Block, provided to you in May of 2016. And this is in that period where you're considering the right of first refusal, correct?
Yes.
And he says in the first paragraph, I have given thorough consideration to the Intellect's proposal for distribution of their new SP technology. By the way, it was new SP technology, right?
Well, I don't know if this is like a conclusive statement on the technology with regard to the terms of the agreement.
And then it says, we cannot feasibly establish profitable operations in Poland, the Czech Republic, and Hungary, especially if we have to open a repair office in each country.
That's what he wrote.
And you believed that at the time, didn't you?
Probably.
And he would know, wouldn't he?
Yeah.
And then he says a couple of sentences down, we simply don't have the resources or contacts to follow through on the contract provision. And you understand he was referring to a contract provision in the Contendo proposal.
Yeah, that's my understanding as well.
I'd like to turn to Exhibit 22 and talk about the growth that you described on direct. Exhibit 22 is, can we use the version that I have in my PowerPoint, please? I have a version of Exhibit 22 that we've highlighted some things that I'd like to show the witness, Your Honor.
Fine.
It's been provided to counsel. And while we're queuing this up, Exhibit 22 is a summary of your sales year over year for 5 years, correct? It actually may even be 6 years.
22, I think it's only for the first and for the second year of the, it says sales for a year, for 2014 and 2000.
Yes, sir. So it's 5 years, 2014, 15, 16, 17, and 18, correct?
Yes.
Can we expand that and go to the next slide then? So if we look across the top, it says country, and that refers to the country in question, sales made in that country, right?
Right.
And then the population of that country in total, correct?
Correct.
And then the percentage of that population against the entire European Union, correct?
Correct.
And then the sales as a percentage of total sales by Cranbrook of SmartPlug, right?
Right.
So all other things being equal, you would assume, wouldn't you, that if the same efforts were made in all the countries, that the sales would roughly match the percentage of the total population of the EU, right?
That would be speculative.
So let's look at what the actual results were. In Greece, for example, a small country, but there were no sales ever in this 5-year period in Greece, were there?
Correct.
And if we go to the next country, Italy, not so small, over 13% of the population of the EU. No sales in Italy for 5 years, right?
Correct.
In Spain?
Counsel, the documents and evidence. I
Well,
think the jury can see this.
Yes, let me ask about the last two on the line, Eastern Europe and Scandinavia. You're aware that those aren't countries, aren't you, sir?
Well, those are the reporting formats we agreed on with Intellex.
Very well, but they're not countries, are they?
No, they are regions.
Okay, and in fact, they each contain a number of countries, don't they?
Yes, they do.
Now, would you agree with me that Eastern Europe has 10 or 11 countries?
Probably.
And that Scandinavia has 3 countries?
Yes.
So if we say 11 plus 3, that's 14 countries that there were 0 sales in, correct?
Correct.
and then you add the other 4 countries there.
Again, I think the jury has the point, Mr. Madison.
Well, let me ask you then, do you think it's best efforts when 18 or 19 of the 28 EU countries have no sales at all?
Well, let me return this. How Intellex jeopardized our efforts when they introduced DSP2 with, and cutting us off from this technology. How could we compete and penetrate the other markets afterwards? So,
But in the very first year of the contract, 2014, you did 0 marketing in 19 out of 28 countries in the EU, didn't you?
well, we did 0 sales.
Well, you're saying you were marketing and just not effective at it?
I have no idea.
I mean, if you convince this jury that you're entitled to somehow keep a share of SP2, does Intellex just have to accept that 19 out of 28 countries in the EU will have no sales?
Sustained.
I mean, don't you believe that Intellex has the right to turn to someone that has facilities throughout the EU and can make sales or at least marketing efforts in 28 out of 28 of those countries?
Sustained. It's argumentative.
Nothing further, Your Honor.
Thank you. The plaintiff rests its case. All right, so that's the plaintiff's case. We're going to take a break now. We'll now begin with the defense case. The plaintiff has rested, so Mr. Madison, call your first witness.
Thank you, Your Honor. We call Willa Judson. Good afternoon, Ms. Judson.
Good afternoon.
Can you tell us where you're employed?
I'm currently employed by Intellex Electronics Incorporated.
And what's your position there?
I'm their Senior Vice President and also the Director of Operations.
Can you tell us what duties you have as Senior Vice President and Director of Operations?
Well, generally I work from a project-to-project basis and pursue our... pursue
not
our,
quite so close. Yeah.
of course, and pursue our business goals. Yes.
Now, we've heard a fair amount of evidence already today, so I'd like to take us directly to that time in 2013 when Intellex and Cranbrook were negotiating a license. Do you have that time in mind?
Yes, it was 2013.
And did you play a role in those negotiations?
Yes, I led the team who negotiated with Cranbrook back in those years.
So what was important to you and Intellex as you went into those negotiations with Cranbrook?
It was really important for us to roll out all across Europe. So it was the United Kingdom, but it was also each country of continental Europe. That was really important.
Why?
Well, it's those video game players, they don't tend to switch platforms very often. So once they've picked one, they tend to stick with it. And so we had to make sure to get to the users first before our competitors do. So
we've heard testimony today from Cranbrook about slow growth and building up. And in your experience, is that an effective marketing technique for video game technology?
No, in my opinion, it is not effective. We wanted to hit the market, and we wanted to hit the European market, not the market of the United Kingdom, which honestly, there we could have marketed ourselves. We speak the same language. We have a strong historically connection to the United Kingdom, but not to the European countries, and there we wanted to be first.
We saw a memo from Ms. Rosenberg in evidence where she used the phrase saturate the continent. Would you agree with that statement that she made or disagree or other?
Well, this is a good goal to pursue, to saturate the continent. Yeah, that's also what we wanted to do, yes.
So let me turn then to your discussions with Ms. Rosenberg. Was she the counterparty that you were negotiating with?
That's correct, Mr.
And did you communicate the objectives that Intellex had with regard to the smart plug technology?
I certainly did. Throughout the negotiations and in the agreement, we made this goal explicitly clear.
And we've seen this memorandum in evidence. It's Exhibit 3, and it's a letter, rather, not a memo. This is is this Exhibit 3? I think we're on a different exhibit. Well, this is the memo that Mr. Morganfield wrote to you in January. Do you recall this?
I recall it, yes.
And we've expanded a section that says, we've reached the point of talking price, and I would like you to take over the negotiations at this point. So do you recall that that was about the time that you assumed responsibility?
Yes, it was.
So then I want to get to Exhibit 3 here, which is the letter of March 4, 2013 from you to Eve Rosenberg at Cranbrook. And what was your purpose in writing this letter?
Well, with this letter, we communicated, I think, also the royalties, but also the explicit goal to market throughout Europe, and that representations of Cranbrook are material to us.
And in particular, this third paragraph makes these statements that we've been through today about our interest in Cranbrook is largely predicated on your representation that you are already capable of distribution all across Europe. Can you explain to us why you made that statement in this letter?
And again, there I wanted to make clear that it's, for us, our goal is to saturate the European continent, and that this was the decisive factor in picking from all the potential licensees precisely Cranbrook.
Had Ms. Rosenberg made the representation that you cite there to her?
Yes, she did.
And it then says, if this is not the case, please notify us at once and we will seek a different licensee.
Yes.
Was that like an empty threat or a real possibility?
That was the inevitable consequence.
Of what?
If she had not made those representations, we would have just sought a different licensee.
So would you say that Intellex relied on those representations?
Definitely, we did.
Now, we've heard a bit about the technology that's involved, and I want to move to the agreement of July 15, 2013. First, this is your signature, is it not, on behalf of Intellex?
It is my signature, yes.
And can you tell us, there's a paragraph about the exclusivity of the license. Can you tell us what your understanding as one of the negotiators was about what the scope of that license exclusivity was?
Yes. Well, in 2013, we had this product called Smart Plug, which was the big hit in the American market and was the most sophisticated device there. And the exclusive license covered explicitly Smart Plug and also directly related products. But what it did not cover was unrelated products, new products, innovations, sensations, which are not even mentioned in the agreement. Those were covered by the right of first refusal, which we heard before.
Did Cranbrook ever request in the negotiations having an exclusive license on all new products?
No, it did not. We were negotiating about Smart Plug.
And so did Intellex ever offer an exclusive license for any and all new products in Europe?
No, they did not, and we would have not entered an agreement about that. I mean, we have a staff and development department who costs us millions and works hard, and we wouldn't give another company our distribution rights before we even created it. I don't know.
Did you have any experience prior to this license with Cranbrook?
No, 2013 was our first contact with Cranbrook.
So would that have been a factor in deciding whether or not to give an exclusive license over numerous products?
If we had good relationships before and we trusted them enough, maybe, but even then I think we would have not entered an agreement about future products. Yeah.
So what was your impression of Ms. Rosenberg?
I was deeply impressed by Ms. Rosenberg. She's, I think, Belgian by birth, spoke many languages, really important European languages, for example, Italian and French. And she had a lot of ties to the European continent, and she made us she assured me that she could make good sales for our product in Europe.
Why is it important to speak multiple languages in doing business in Europe?
Well, I also have some expertise in marketing, and it's important to know the regional differences of each country and also to understand the language, and that was a really material factor for us.
So in the license agreement, there are numerous references to the geography that's involved in the agreement. So here are a couple of those provisions. Talks about Europe in the first bullet point there, the whereas, and then number 4 actually calls out in the United Kingdom and throughout Europe. Why was that language included, if you know?
Yes, we really wanted to make it crystal clear that they should not only focus on the United Kingdom, where they are located at, because there we knew they were performing quite well, but even to add it expressly that the whole European continent was meant. And yeah, as I also said, this little island we could have maybe handled on our own, but we wanted to make sure to hit the European market.
And I believe there's even a reference here to, well, this is the right of first refusal for the new leisure products that we discussed. But there's also a definition, of the term Europe. One would think perhaps that would be self-defining. Why is there a definition of Europe in the license agreement?
Again, as I mentioned, another argument to strengthen our position and to make it to Cranbrook sure that this was so important for us.
So this refers to the European Union and any other nation situated wholly or on the landmass of the European continent, including Mediterranean, North Sea, Baltic. What was your understanding at the time in 2013 of how many nations were in the European Union?
I think back in 2013 it was also 28, the number we heard before, so each country.
So what was your expectation of performance by Cranbrook in terms of trying to promote, market, manufacture, and distribute smart plug technology?
Well, that there are sales in every of these 28 countries.
Is there some reason that some gamers or consumers in one country or another might not be interested in smart plug technology?
No, there's no reason why this should be the case. We don't understand why people from the Czech Republic and young people from Scandinavia shouldn't be able to play our games. Yeah, no.
Did you, when you saw the sales results for Cranbrook, did there come a time when you saw sales results?
And there did come a time, yes.
And what was your impression or reaction to that?
Well, unfortunately, we were really disappointed. We had great hopes in this cooperation, and we're genuinely sorry that it did come to this dispute now. And the sales were flat. It was far too Anglo-centric for our true needs. And there were no sales in major countries, which we just didn't understand. And I think 1/3 of the European population wasn't targeted at all, apparently, because there were 0 sales.
Now, did you take these matters up with Ms. Rosenberg?
Unfortunately, I couldn't.
Why not?
She wasn't there anymore, as she left the company.
And what were you told, if anything, about why she left the company?
I've not been told any reasons why.
So did Ms. Rosenberg or Mr. Nichols ever explain to you that there had been a disagreement inside Cranbrook about something called the British strategy?
I wasn't aware of any British strategy, and that's really shocking, because the British strategy is the opposite of what we agreed on. We didn't want a British strategy. I know that the UK is really special and holds himself really important, but we wanted Europe, not just UK.
Did anyone at Cranbrook ever inform you about the reasons that Ms. Rosenberg left having anything to do with this smart plug project?
I wasn't aware of any, no.
Now, this article was shown earlier. It's a January 2015 article from Games and Toys Weekly. And in particular, you made some quotations there in the paragraph that's on the right-hand side. Do you recall the interview?
Yes, I recall getting interviewed by the journalists right after we launched the new product, SP2.
And do you, as you read that paragraph today, do you believe that you made the statements that are reported in the article?
I made those statements, that's correct.
Do you believe, did you believe them at the time to be true?
Yes, at that time, that was my understanding at that time, yes.
Okay. As we sit here today, do you believe your statements were accurate?
No, in fact, it is like that SP2 can play both games, but SmartPlug cannot play those games that combine logic and action. Those can only be played by SP2. So I did not make any precise technical distinction in that interview, but it was also in a marketing context, and now I know it's not quite correct, yes.
Now, the license agreement, Exhibit 62, defines the terms smart plug and smart plug products, and in part it uses the phrase based on, designated to use, or otherwise exploit the smart plug microchip technology. Does SP2, is it based on, designed to use, or otherwise exploit the smart plug microchip technology?
No, it's not. SP2 is a different microchip, it's a different material, it's covered by a different patent, it has different functions and features, it can play those logical, complex, cerebral games that a smart plug cannot play, so it cannot be an improvement, a modification, or based on something from smart plug, because smart plug couldn't do it. So.
Now, do you recall writing to Games and Toys Weekly after this article appeared?
Yes, it was shortly after, yeah.
And
That's the letter. Yeah.
A January 22 letter, which appears to be just 3 days after the article here. And why did you write this letter to Games and Toys?
I wanted to, what did I write? I wanted to, it was my, I wanted to protect the picture of our two companies there. I did not want a private dispute to be out in the public. And also, our private sales figures weren't public, so competitors shouldn't be awakened about those market gaps in the European country, which Cranbrook unfortunately created in, for example, Eastern Europe. And so I wanted to make this clear to the press.
So if we look at this middle paragraph in particular, you make a statement about Cranbrook, the distributor, doing an outstanding job of getting the Intellect's message spread across Europe. And did you have a basis for that conclusion that you stated in the letter?
Well, actually not. They did not perform satisfactorily. But again, here we were in an ongoing relationship, and I didn't want to discourage them. And we were afraid that they would stop performing at all, and not even the young people in the UK were able to play our smart plug games anymore. And yes, so.
So did you ever announce publicly through Games and Toys Weekly or any other way that Smart Plug was not being marketed in many EU countries?
No, I did not, but again, to protect our company. It was a business decision, yes.
What do you mean by that?
Well, if competitors got really aware that there were places where we had zero sales, I think then they would see, a market need to fill. Why don't we step in if their licensee is not able to do that?
Is the video game business competitive?
It's a very competitive environment. You have to be fast or you're out.
So did, based on your understanding of the technology involved and the contract that you negotiated, as we stand here today, does Cranbrook have an exclusive license to SP2?
Certainly not.
And to your knowledge, did anyone inside Intellects ever believe that they did?
No, honestly not, no.
So we have these sales percentages, and I've shown them several times, so I won't dwell on them except to ask you, was it your understanding in negotiating the contract that the majority of EU countries would receive no marketing at all from Cranbrook?
Of course not.
Overruled.
Of course not. We've picked Cranbrook, but because it was represented by Ms. Eve Rosenberg, and a woman who could speak fluently Italian, and now we have 0 sales in Italy. This cannot be true.
And so if Cranbrook were to continue to be the exclusive licensee, not just for SmartPlug, but to add SP2 also, would it be acceptable to Intellex to have 0 sales in the majority of EU countries?
It would not be an acceptable situation. We could not sell our product in Europe, which we really, really want, and yeah, we would be really disappointed.
And were you involved in the renewal of the license with Cranbrook?
I think I did not sign the renewal contract, but it was also my suggestion, yes.
Well, I'll ask Mr. Morganfield about that then, and also were you involved in the negotiation of the Contendo license for SP2?
No, I wasn't involved in this at all.
Okay, thank you, Your Honor. Nothing further.
Cross-examination?
Good afternoon, Ms. Judson.
Good afternoon, Ms. Sheth.
The CEO, Ken Morganfield, asked you to handle the discussions with Cranbrook, right?
Right.
And that was your responsibility.
Yes, we were a team of 3 people, but it was my responsibility, yes.
And the CEO specifically told you that the license should cover only SmartPlug, right?
Yes, there was only SmartPlug to negotiate about, yes.
And he specifically told you that Intellex had a new plug on the drawing board, and that new plug was called Smart 2, right?
That's correct, yes.
And he also told you that it was essential that the contract preserve the option to negotiate a new deal for Smart 2, right?
That is also correct, yes.
And the Smart 2 is what later became SP2, correct?
Yes, correct.
And he told you to make sure that Cranbrook understands the distinction between SP2 and SmartPlug.
I think he did, yes.
Okay. Now, you didn't make that distinction clear to Cranbrook, did you?
To my understanding, it was pretty clear in the agreement. We had only SmartPlug to talk about. Those Smart 2 was just an idea in our thinking tank, which would never come to existence, maybe.
Well, you're saying that Smart 2 was just an idea in your thinking tank?
That's, yes.
Okay. Isn't it true that, that the CEO specifically told you that Smart 2 had the potential to, Smart 2, and actually let me just show you the document so you have the benefit of it. Let's take a look at Exhibit 1. And if we scroll down to the bottom of the document, there we go. Ms. Judson, isn't it true that Mr. Morganfield told you that the new plug would knock the socks off of anything now in the market, right?
Yes, he told me that, but he says that a lot about a lot of products which never come into existence, which were just a waste of money in the end.
Well, he also told you that if development succeeded as planned, this plug would dominate the worldwide market, correct?
Yes, correct. But again, that's just a hope in that time. Yeah.
But you didn't mention the SP2 to Ms. Rosenberg, did you?
That's correct. I did not mention it, no.
Okay. In fact, you told her that Intellex did not anticipate introducing any other products in Europe, right?
That was, yeah, but that was also correct at that point of time. We were only planning on expanding SmartPlug, the most sophisticated device in that time on the market.
Well, you talked, Mr. Morganfeld told you about worldwide domination, right?
Yeah.
And the world includes Europe, doesn't it?
Yes, it does, yes.
Okay. Now, you, in fact, told Ms. Rosenberg that Intellex looked forward to Cranbrook marketing SmartPlug or any plug, correct?
That's correct, yes.
Okay. And in the final contract that you negotiated with Ms. Rosenberg, you did not expressly exclude the SP2 product, right?
That's correct, but SP2 didn't even exist in that time, yes.
But you had a name for it. It was Smart 2, right?
Yes.
And you didn't exclude Smart 2 either?
I did not, no.
Okay. And you actually, in this prior document, Exhibit 1, You had asked for a 15% raise from the CEO, right?
Yes, correct.
And he told you if you can close this deal, he would look favorably on your request for for your otherwise outrageous request for a 15% raise, right?
Yes, that was Ken's answer to my request for a salary increase, which I had deserved for a long time, but yes.
Right. And he told you if you didn't close the deal, that you shouldn't even consider the possibility of a 15% raise, right?
Right, that's what he said, but this didn't influence the way I conducted the negotiations with Cranbrook in any way, so
Well, you didn't tell them about SP2, right?
that's right, yes.
And you didn't tell them about Smart 2.
But I just saw this, I saw the statement as an incentive to do my job at the best of my abilities and not to not disclose anything in the negotiations. I was being honest and truthful.
Well, were you being honest when you told Ms. Rosenberg that Intellex did not anticipate introducing any other new product in Europe?
That was really my understanding in that time. I couldn't be sure that there would be any product that would come out and...
Well, you couldn't be sure even though the CEO told you that there could be worldwide domination if the Smart 2 product came about.
But again, I think it was a vague idea of him, and I wouldn't even know how to put this on the negotiation table. Like, we also have something else, but it's up in the clouds. It might come up, it might not come up.
But you didn't mention either.
I didn't mention it, that's correct.
Okay. And you knew that if you mentioned SP2, that there's a potential that the deal may not have closed, right?
There may be a potential, but I think it was about Smart Plug. They wanted Smart Plug, and they got Smart Plug, so...
Well, they wanted Smart Plug and any improvements to Smart Plug, right?
Right.
Okay. And if the deal didn't close, you were not going to be considered for your 15% raise.
That's what Ken says there, but I know Ken a long time, and I think he would have recognized my abilities and given me those 15% salary raise anyway.
Even though he thought your request was outrageous?
He picks his words sometimes quite fiercely, but...
Okay. Now let me show you what's been marked as Exhibit 15. This is an article in Games and Toys, right?
Right.
And this was announcing the launch of the SP2 product, correct?
Correct.
And in the story, it says, all observers agree, this is at the top of the second column, that the SP2 chip is an outstanding modification of the smart plug technology. You see that, right?
I can see it, yes.
And you read this article when it came out, correct?
I did, yes.
And you were interviewed in connection with this article, right?
Yes.
And in fact, you were even quoted in the article, right?
Right.
And in that quote, you stated, a little also in the same column, that Intellex had an excellent technical base in smart plug and that you intended to build on it with SP2, right?
Right.
And you also noted that this relationship between the two products was perfect.
Correct.
And you also noted that each product would be able to run all of the software intended for the other.
Correct, but...
Now, the correction you're making today is that the smart plug cannot play the complex games, right?
That's correct.
So, in fact, SP2 is better than smart plug because it can play both fast-paced games and complex games, right?
It's not even better. It's like a huge new sensation, an innovation, not an improvement.
Well, earlier during your direct, you mentioned that it was an improvement and a modification.
No, it just goes away from improvement and modification.
Well, isn't it better if the product can play two kinds of games versus one kind of game?
That's certainly better, but I meant to say it as it's kind of been improvement or a modification if it creates this whole new feature of playing both games.
So a whole new feature is better than the old game, right?
Better in a whole new level, on a whole new level, yes.
A whole new level of better.
Yes.
Okay. And isn't it also true that the smart plug product cannot play complex games? It only can play action games.
That's correct. It's designed for speed and action, yes.
Okay. And so if a new consumer comes to the market looking for a game product, it would be fair to say that new consumer would rather have a game that can play both fast and complex games, right?
That is correct, but the user experience is also quite different on both products. So on SP2, those really only complex, there's only action speed games are played a bit slower. So there's not the same user experience, and one product is no replacement for the other one. So there is still a market need for both.
Well, only a market need to the extent somebody wants to be limited to action games, right?
Yes, but there are people who want that.
And isn't it true that the SP2 product plays action games 20% faster than the Smart Plug product?
I cannot recall that this is. I'm not sure if this is true.
Now, you wrote a letter in response to this article, right, to the editor?
Right.
Okay, let me show you that document, Exhibit 16. Now, in that letter, this is the letter that you wrote, correct?
Correct.
And in that letter, you described SP2 as a remarkable improvement that would revolutionize the video game market, right?
That's correct, yes.
Okay, and you also wrote that you had an issue with regard to the editor's comment about slumping smart plug sales in Europe, right?
Right.
And you didn't express any disagreement, actually withdrawn, and you further went on to say that Cranbrook, the distributor, has done an outstanding job of getting the Intellex message out there, right?
Yes, as an encouragement to not disappoint them.
And you also told them that it had done an outstanding job with regard to getting the message spread across Europe, not just the UK.
Yes, that was also a conclusion in that time. That wasn't entirely what I really thought, but yes.
But the article itself didn't mention anything negative about Cranbrook, did it? All it noted was that the sales were slumping. It didn't say Cranbrook was doing a bad job, did it?
It didn't, but sales are slumping has the connotation of being not as good as it could be.
But you could have written to the editor and said, sales are not slumping. You didn't need to go beyond it and say that Cranbrook was doing an outstanding job, did you?
Well, I didn't want to present wrong figures because the sales were slumping. I just wanted to make the subjective conclusion there.
And your subjective conclusion was that Cranbrook was doing an outstanding job, right?
Yeah, for this public purpose, for this public documents, yes.
Okay, let me show you the contract itself. If you could pull up Exhibit 62. Now, Exhibit 62 is the licensing agreement, right? Yes. Do you recognize that document?
I recognize it, yes, our 2013 agreement.
And it's your signature on the last page, right?
I think so. That's my signature, yes.
Okay. Now, if you look at paragraph 2 of the agreement, it states, this license is granted for a period of 5 years and shall be renewed for a further period of 5 years upon satisfactory, substantial performance of each party, right?
Yes.
And the contract does not require Cranbrook to provide to your highest expectations, does it?
For the extension clause, not, no.
Okay. And for the marketing clause, it requires best efforts, right?
Right.
And you thought Cranbrook's performance was satisfactory, right?
No, actually, I did not think that it was satisfactory.
Okay, let's take a look at Exhibit 23. Do you recognize this document?
Yes, I recognize it, yes.
Okay, this was an email that your CEO had sent to you about Cranbrook's performance, right?
Correct, yes.
And if you look at the second paragraph, if you could just read that sentence to the jury, the second sentence.
I'm not at, it starts there, I'm not at all happy.
Yes, the second sentence of that paragraph.
I'm not at all happy that we may be stuck having Cranbrook distribute smart plug for as many as 8 more years. These results are satisfactory for now, but they aren't what we need to maximize our position.
So the CEO told you that the results are satisfactory for now, right?
Right.
Okay. But he still was not happy.
No, it wasn't, because it was far too Anglo-centric. It was only in the United Kingdom and not what we had agreed on.
Okay. But in your contract, you didn't specify a time period for expanding into the rest of Europe, did you?
No, we did not, but European strategy meant hitting the European market at once, from the beginning on, and not in 10 years or 4 years.
But you didn't include that in the contract, did you?
That's correct. We included Europe as in many possible ways as possible, yes.
Yes, but you didn't specify the time frame within which Europe had to be marketed to.
No, we didn't.
Okay, no further questions.
Nothing further. All right. Defense res?
No, we're calling Ken Morganfield.
You're calling another witness?
Yes, Your Honor.
All right. Is this your last witness, I hope, Mr.
Yes, Your
Madison?
Honor.
You know,
Yes,
you've really imposed on these very nice people here.
I deeply apologize that Cranbrook made us do this.
Exactly.
Good afternoon, Mr. Morganfield.
Good afternoon, Counsel.
So I'm afraid you're the one to blame for all of this because you invented the smart plug technology, did you not?
Yeah, this seems to be the position of Cranbrook, yeah.
Can you pull the mic just a tad
yes, of
closer,
course.
please? Yes, and
Sorry.
speak clearly.
Okay.
So let me ask you first, when did you found Intellex?
In 2010, like 9 years ago, yeah.
And what was the first significant product that you had?
Well, we turned out to be lucky. We invented, like, after 1 year of business, we invented the smart plug, the product the ladies and gentlemen of the jury heard about. And yeah, we were fortunate. It was a really big, great success in the US right from the start.
Now, you may be somewhat modest about it, but who was the person that created smart plug?
That'll be me, Counsel.
And did you obtain patents on the smart plug technology?
Yes, sir.
So after the success in the US, what strategy did you have about the future of smart plug?
Yeah, as always in business life, the next logical step was expansion. So we give it some thought, and we're trying to figure out whether myself is Asia an option or will it be Europe? And then we turned to Europe, like in 2013, and tried to find a partner.
So we've heard a fair amount of testimony about the license agreement and the marketing in Europe. Perhaps as CEO and founder of Intellex, you could share with us what your understanding was about what an effective marketing campaign would be.
Hit it all at once, of course. I think we heard it before. We are in the gaming business. Gaming business is not like, I like wooden toys also, great stuff. But in the gaming business, you need to be quick. You need to be published or you're out. So our absolutely clearly goal, and this was clearly from the beginning, and I talked to Mr. Nicholson, we met in person, was we want to provide our product to all the European countries and not, as it seems to be, or the opinion of Cranbrook, just Great Britain. So it needs to be Italy, Germany, France, Eastern Europe, and so on and so on.
Well, did you know that Cranbrook did not have any facilities on the continent, that they were only in Great Britain?
I'm not so sure about the facilities, but I think we made it clear, and they just told us they had that guy, and that guy turns to be also a lady now, who has like great experience, great connection, and could do the marketing all over Europe. So we were clear about the fact that they are UK-based, but we were also expecting, and at least this was the impression which they gave us, that they were able to provide our product all over Europe.
And did there come a time when you learned about Eve Rosenberg and her involvement on Cranbrook's behalf?
Yeah, I think Willa told me, and so she was actually the one essential person why we thought we give it a try. We can do it with this Britain toy company, and we may succeed, yeah.
So there's been a suggestion and an allegation that SP2 is both included in the exclusive license that Cranbrook already received for SmartPlug and is subject to the right of first refusal. Can you tell us what your understanding about those two requirements are?
Just to be honest, I think this would be insane. You know, like I told, we are in the gaming business. So why should I show my technology or things I develop, me and my partners? Why should I show it to any business partner? Will I make this, for my understanding, crystal clear? It was a project at that time. So we were talking about SP. The smart plug, this was the one thing we were talking about with Cranbrook, and like SP2, yeah, there's a name, of course, because SP was known in the market before, but SP2 was a project among other projects. As a company, we're taking risks, sometimes we succeed, sometimes we find something great, but very often we don't. So, as I mentioned, a project at this time, and for me it was clear, SP1 is subject to the license agreement, and there we can talk about this, I always forget the name, the right of first refusal. That may be another discussion, but certainly no license with regard to SP2.
Well, let's stick with the license for just a moment. There's language in the license agreement about technology being an improvement or a modification based on the smart plug technology. So who invented SP2?
It'll be me too, sir. Yeah.
Okay, so let me ask you, is SP2...
No, not at all.
Let me finish the question.
Sorry. I'm just so upset. That's
Is
The witness will
SP2...
just answer the questions, please.
Yes, Your Honor.
Is SP2 based on smart plug technology?
No, it is not.
Describe SP2 technology.
SP2 is like different. It's like comparing like a motorcycle to a horse. So both of them like go forward, but SP2 is way quicker. And as the counsel mentioned before, SP2 can also be used for like the more European-style cerebral games, whereas SP is just for like action gaming, which is a great thing. But SP2 exceeds it on all ways, and not only that, it is like based on a total different technology. It's a total different manufacturing process. There's nothing in common aside the name.
Have you, well, can you address why there's a similarity in the name? It's not the same name, but SP might suggest to a SP2 might suggest something.
Of course, we were known by the customer. This is like simple marketing. This is business. You need to sell something. So why should we come up with a different name? As I mentioned before, it was a project. We thought of like Smart 2, Smart Plug 2, but we want to stick to that because we were known. We were associated with this name as a company. And also SP is like old-fashioned. No, it was a great product and it had a great impact, and we had a really good reputation in connection with this product we just wanted to use.
So, to be clear, was it your intent in entering into or authorizing Ms. Judson to sign the license agreement, was it your intent to include SP2 in the exclusive license?
Certainly not.
Have you ever, in the history of your company, entrusted an exclusive license broadly to a counterparty that you'd never worked with before?
No one would do so.
So what was your intent with regard to the smart plug technology working with Cranbrook?
We wanted to give it a try. They told us about Ms. Rosenberg and her connections and the marketing abilities, and we just wanted to find out whether they're just good, whether they can perform well, whether they may be a partner for a long-term relationship. But I know nobody in business who just entered into a long-term relationship without really knowing your counterpart. This was like an acceptable risk at that time regarding the SP, but nothing further.
So let's turn to the right of first refusal. And we've seen Exhibit 30, if we could have that here, please. And I want to ask you first, just as foundation, did you in fact negotiate a proposal for SP2 with Contendo?
Yes, sir, that's correct.
Now, the Cranbrook agreement required Intellects to give Cranbrook notice of and a right of first refusal to any new products.
That is correct, yes.
So were you happy with Cranbrook's performance?
No, I was disappointed.
But did you consider not complying with the license agreement's requirement that you give notice?
Not a minute. as a businessman, I believe in contracts and I believe in honoring those contracts, and that is how we do it as company.
So is Exhibit 30 the notice that the license agreement required with regard to this right of first refusal?
That is correct.
Now, we've heard testimony that the contendo proposal was attached here. So I just want to ask you about this small paragraph right in the middle. I don't think anyone's discussed this yet. It says, please be advised that you now have 30 days within which to match or exceed the exact terms of CGNV's proposal. Let me just stop there. Was it your understanding that the license agreement provided a 30-day period for the right of first refusal?
Yes.
Was there any requirement in the license agreement that you call that out for Cranbrook?
No, but that's like fair business for me, so we did it anyway.
Can you explain what you mean by that?
This is like, you think, I believe in, we still have this relationship, we're not happy with them, but still, like I said before, as a company, we try to honor our obligations, our contracts, and our business partners. So I thought it's no harm just to point out, okay, you have 30 days, and to make absolutely clear, because to be totally honest, I wasn't that so sure at this point how into Mr. Nicholson is into this whole business thing. So I just wanted to make absolutely clear where we are, what we would expect, and how this will or could proceed between this business agreement between my company and his company. So there was no such obligation in the contract, but anyway, we do not want any, how to say, we just wanted to make it clear for him.
So the next sentence says, we will not consider or accept a counteroffer. Why did you make that statement?
Again, so to clear things up, to make absolutely clear where we are and what may be a ground for further business relationship, and certainly not a counteroffer or something. So we had a plan at this point, you know. We had a plan how to proceed, how to marketing the SP2 product, and we do not want Mr. Nicholson or his company to interfere, because he has turned out to be not into this gaming industry. And as Ms. Rosenberg left the company, there was no reason for us why we should take any suggestions for him regarding this gaming industry concept.
So if that's true, then let me ask you two questions. First, why did you offer $100,000 to buy out the entire right of first refusal to new products from Cranbrook?
As I said before, so first of all, it's business, you know. Actually, for me, I'm just losing money sitting right here now. So it's business. We wanted to clear things. We wanted to, to separate in good mood. And this is why we offered it to him, because actually I was under the impression he'd take the money and understand and notice for himself. We have seen the 0 sales, that he did poorly. And was like a generous offer from our side to end this relationship in a civilized manner and not go to court. Sorry.
Was it a business decision?
Yeah, of course. Yeah.
And litigation's expensive, even if you use a firm as reasonably priced as Quinn Emanuel.
Absolutely, yes.
Okay. And then the second question that arises is, why did you enter into a 5-year renewal with Cranbrook for SmartPlug?
Yeah, this time we already published SP2, but there was still a niche or a small market for SmartPlug. And because Cranbrook had this infrastructure and they already marketed, we thought it might be a good idea to just let them do that. But yeah, I'm not sure if niche is like the right legal term, but again, this is just simple business. They could do that, so we left it with him.
So let me ask you about the Contendo proposal then. Did Contendo have sites on the continent?
Yeah, they did. Yeah, they had a lot of boots on the ground. That was what we are looking for at that time. Yeah.
In your opinion, do consumers sometimes prefer to bring a problem product into somebody and explain it in person?
Sustained.
So was it a factor in your mind in considering the Contendo proposal that they had sites in Europe on the continent?
Yeah, sure. You know, Europeans are sometimes old-fashioned, so.
And there's been a statement made that you had a side deal with Contendo. Did you have a side deal?
No, of course not.
So what actually occurred after the contract with Contendo about the repairs?
They had these facilities before, and just we had an agreement with them, as you can see in the exhibits, that they built these, or they changed these offices they had in Eastern Europe into like repair sites. And as far as I can recall, they will do so like in the end of 2021, like in 2 years, this will be done. So they have these repair sites, and for the time being, we have like people sitting there, we have desks, our consumers can go there, talk about the problems, and we have this term, I used it before, we have boots on the ground. We can do it what we wanted to do before. We can provide our product all over the continent.
So after telling Cranbrook that they should not submit a counteroffer, what response did they bring to you?
Yeah, they submitted a counteroffer. Yeah.
Why do you say that?
Because it was actually Willa and I, we were like, okay, well, what is this guy doing? So we pointed this out explicitly, and he was like, okay, we're not providing these repair sites, and there was just another term, I always forget the legal language, it was like liquidated damage provision, and they didn't come up with that. They offered us like a higher royalty, but at this point, we didn't believe in them anymore. So what's the point in getting a higher percentage if there are no sales? So there's no money in it, so why should we do it?
So to be clear, did Cranbrook ever offer to construct and establish and run any facilities on the continent?
No, never.
Did Contendo have a commitment about facilities on the continent?
Absolutely, yes.
Now, we've seen the results of Cranbrook's efforts, and if we can just call up Exhibit 60 again very briefly. When you learned of the sales that, I'm sorry, let's look at Exhibit 22, please. When you learned of the sales that Cranbrook was reporting, were those what you had expected from Europe?
No, we agreed upon best efforts. And I think I made this absolutely clear to Mr. Nicholson when I met him. European approach. It's not about the UK. You know, I like England, I like being there, but in the US we have like 200 million potential customers, or let it be 100 million. Well, there's no use turning to like a 60 million population. We need the whole European continent, and we need to be the first. We had the product at this time. It sold very well in the US, and yeah, this was our approach, which, of course, as you can see clearly from these figures, didn't work out with Cranbrook.
We heard testimony from Mr. Nichols that well over half of the countries in the EU have no sales.
Yeah.
In your experience, if there is marketing of your products, would there be sales?
Of course. Yeah.
And was it satisfactory to you to not have sales in the majority of EU countries?
No, it was not. You know, like teens are all the same worldwide. So we sold like bunch of products in the United States to teenagers, and obviously their parents. We sold it in a lot of countries where they obviously did the marketing, but in some we sold like nothing. And it's not like the people are not interested in computer games, it's just other firms right now who are earning the bucks there, not us.
Has Cranbrook ever given you any reason to believe that the sales for these European countries would be different for SP2 going forward?
No, sir.
Have they ever provided a marketing plan for all of the European Union?
Never.
Nothing further, Your Honor.
And cross-examination? Yes, Your Honor. So be glad to know, ladies and gentlemen of the jury, this will be the last examination, the cross of the last witness.
All right. Good afternoon, Mr. Morgenfeld.
Good afternoon, Counsel.
Let me show you Exhibit 15. This is an article about SP2, right?
This is correct.
And your testimony on direct was that SP2 was a potential new product, right?
This is correct, yes.
But as early as January 19th of 2015, excuse me, let me give you that right date, as early as January 12th, excuse me, of 2013, you had told Ms. Judson that your new plug would will knock the socks off of anything now in the market, right?
Yeah, but I'm not sure about the words I used that time, but when it came to be a product, this was our expectation. That is correct, yes.
Okay, well, let's take a look at your exact words. Let's look
Thank
at
you.
Exhibit 1. Now, this was a memo that you wrote to Ms. Judson, right?
This is correct.
And you wrote it as early as January 2013,
This
right?
is correct, yes.
And that's 7 months, approximately 7 months before you entered into the contract.
Yes.
And at that time, you wrote, "Our new plug will knock the socks off of anything now in the market," right?
This is correct, Counsel, but I also write that, this is a new plug on the drawing board. This is like the paragraph above. So it was a project to us. So of course, you're always confident and you hope you find a great solution and a great product you can offer, but on the drawing board, not like it was there at this moment.
Well, it didn't exist, but you didn't say our new plug may knock the socks off. You wrote, "It will knock the socks off."
Yeah, but that's who I am, to be honest.
Okay, well, you also wrote, "This plug should dominate the worldwide market," right?
We hoped at this point, yes, of course.
And in fact, by 2015, when this article came out, the new plug was dominating the market, right?
Yeah, we were fortunate again, and it did, yes.
And it was so fortunate, you were so fortunate that you decided to expand from the United States into Europe with the SP2 product, right?
This is correct, yes.
And in fact, you entrusted your subordinate, Ms. Judson, to engage in those contractual discussions.
This is correct, yes.
And you could have reviewed the contract before she finalized it, right?
I could have, that is correct.
But you didn't do that, did you?
No, because being the CEO, I have a lot of obligations to fulfill, so normally I left the details and the legal terms to the experts.
Okay, and one such detail was that you told Ms. Judson to explicitly exclude the SP2, or as you called it then, the Smart 2 product, from the scope of the license, right?
Not the Smart 2 product, but the project on the drawing board, but this is correct, yes.
Right, and the Smart 2 project was the project on the drawing board, right?
This is correct, Counsel.
Okay, and you agree with me that she didn't follow your instructions, did she?
I'm afraid I cannot agree on this point, but actually, as it turns out now, that's because we're meeting here right now, Cranbrook didn't get it correctly, but from my opinion, we made it crystal clear to them in person and in this agreement. And if I just may add this point, this is what Mr. Nicholson testified here. He described it as a new technology, and that is what it is.
Okay, let's break down your response, and I want you to answer my question. So my first question to you is, did you instruct your subordinate, Ms. Judson, that you want to be able to negotiate a new deal if and when the new plug, Smart 2, hits the market?
This is correct, Counsel.
And you also told her, make sure that any contract preserves this option.
This is also correct, yes.
And you also told her this is essential.
Because, as I said...
Yes or no? Did you tell her it was essential?
Yes, Counsel. Yeah.
Now let's take a look at the contract, Exhibit 62. Now, if you look at paragraph 11B of Exhibit 62, isn't it fair to say that nowhere in Exhibit 62, paragraph 11B, is there any reference or carve-out for SP2?
No, not explicitly. That is correct, yes.
Okay. Now, you were interviewed in connection with the launch of SP2, right?
This is correct, yes.
And that was in Exhibit 15 we were just looking at. right?
Yes, yes,
Now,
ma'am.
when you're talking with the press, you want to be accurate, right?
Normally, yeah, of course you try to be accurate, sorry, but you always try to do your marketing, you know. So
Right. And you gave quotes to this article, quotes to the reporter in this article, right?
this is correct, yes.
And you were quoted as saying that that SP2 picks up and improves on the processes that we began with SmartPlug, right?
Yes, on the process, but not on the product.
Okay, well, it improved on the process.
Yes, I did.
Okay. Now, you agree with me that SP2 runs both action games and complex games, right?
It does, correct.
And SmartPlug only runs the action games.
This is correct, yes.
Okay. Now, you also were notified about Cranbrook's sales and market penetration figures, right?
Yes,
And they told you, Cranbrook told you, that their sales were on target, correct?
yes, ma'am.
And they also told you that their sales were growing steadily.
Yes,
And they also told you that the market penetration was growing steadily.
from their view, yes.
Right. And they provided you with specific numbers for each of the countries, both in the UK and in the continental Europe.
Yes.
Okay. Let me show you what's been admitted as Exhibit 22. And this is the document that they provided you with in early 2016, right?
This is correct, yes.
And it shows the sales and distribution figures for the last 2 years, right?
This is correct.
And if you look at the total sales in year 5, excuse me, not in year 5. Read that. If you look at the bottom, the sales went from 2 million to 2.2 million, correct?
Yes, just give me a second. Yeah, yes, Counsel, that's
Okay.
correct.
And at no point in time did you write back to Mr. Nichols and say, these sales are not good enough, did you?
Yeah, but, you know, Euro sales are never good, so I was quite sure he knew that.
Can you repeat that?
I think there were some countries where they sold nothing or they didn't sell any products, so I was quite sure he was aware of his performance or the performance of his company. So
Okay.
this was because I was not making any statements to him, but as you mentioned, this is correct. We didn't have a contact or a conversation about that. Yes,
Right. And those were the sales in the first 2 years, right?
exactly. Yes.
And you didn't tell him, I'm surprised that you're not, that your sales outside of the UK are not as large as I would have expected.
No, just perhaps I should have done, but at this point I believed he knew for himself. Yeah.
But you didn't tell him.
No.
Okay. Now, you wrote an email to your subordinate, Miss Judson. Let me show you Exhibit 23. Okay, while we pull that up, in the second paragraph of that email, you describe Cranbrook's results as satisfactory, right?
Yes.
And you noted that the trend was definitely positive.
I wouldn't call it that way, but there was some improvement, yes.
Well, aren't those your words where it says, while this is definitely positive?
Just give me a second, I have to remind myself. Second paragraph?
First paragraph.
First paragraph.
While this is definitely positive, they are far too heavily concentrated in the UK.
Sorry, I was just reminding the second sentence where I expressed my disappointment, but while this is definitely positive, they are far too heavily concentrated in the UK, so those are my words. This is correct, yes.
Okay. Now, you recognize that their results were satisfactory, right?
They were okay, and you also could call it satisfactory, yes.
Okay. And the contract only requires their results to be satisfactory, right?
Yeah, and the marketing to provide best efforts all over Europe.
But you were not happy with them and you decided, I want to find a new partner, right?
I have to act in the best interest of my company and my employees, yes, ma'am.
Right. And so you directed your subordinate, Ms. Judson, to look for a new partner.
Yes, this is correct.
But you knew that for SB2, they had a right of first refusal.
This is correct, yes.
Okay. And you were hoping they wouldn't exercise that right.
Actually, I was hoping that at that point, because they turned out not to be the partner we hoped them to be.
And you were hoping maybe you could buy their rights, buy their right of first refusal.
Yeah, this happens frequently, yeah.
But you didn't have any success in buying their right of first
No.
refusal. And so then you considered structuring the deal in a way that they couldn't match it, right?
No, this doesn't draw the whole picture. Actually, we wanted to make sure that I used it before, that we have these boots on the ground all over Europe. So we wanted to provide, or to get to an agreement and to have a partner who allows us to play safe this time, because the first approach didn't turn out to be what we hoped for. So we thought, okay, when we gave it a second try with the SP2, with a product who turns out to be so good in the US, we wanted a company and we wanted a deal which is safe, which enables us to sell as we wanted to.
Did you hear the question?
Yeah, so you have to repeat.
Would you
Let's try that
repeat the
again.
question? And
I'm sorry.
could you listen to the question, please, and see if you can answer it?
I will, Your Honor.
Okay.
Thank you. Go
You
ahead.
considered structuring the deal in a way that Cranbrook could not match it, right?
We were hoping they would not match it. That is correct, yes.
Okay. But you actually structured the deal in a way they couldn't match it.
Yeah, we were not intending to, but this was like one reason we structured it like we structured it. That is correct.
Is
yes.
your testimony today that you were not intending to do that?
No, they were like two parts. This was what I was trying to explain. Of course, we are trying to look for new partners, so we can succeed with our product. But it was not like this was the sole reason why we structured the deal we structured and the way we structured it.
Well, let's take a look at Exhibit 26. This is a letter or a memo that you wrote to Ms. Judson, right?
This is correct, yes.
And if we look at about the fourth paragraph of that letter, starting with more promising, do you see that?
Yes.
You wrote, more promising is the possibility of structuring CGNV's offer in such a way that Cranbrook will be unable to match it. Do you see that?
Yes, ma'am.
And fair to say CGNV is Contendo, correct?
This is right, yes.
And so you were contemplating as early as April 16th, 2016, to structure the deal in a way that Contendo could not match it.
This is correct, yes.
And the way you did that was by having Contendo offer these repair sites in Eastern Europe.
Yes, so this is correct.
And you knew that Cranbrook did not have facilities in Eastern Europe, right?
This is correct, yes.
And you knew that Contendo did.
Yes.
Okay. Now, you went so far as to have conversations with Contendo itself about what it could offer that Cranbrook would not
This
be
is
able to
correct,
offer.
yes.
And the person you talked with at Contendo was Helmut Platter.
Yeah, the CEO, right.
Okay. And let me show you what's been marked as Exhibit 27. This is a letter that Mr. Platter sent to you, right?
This is correct.
And he offers, quote unquote, several services that Cranbrook will not be able to match, right?
Those were his words, yes.
And one of those was these offices located in Warsaw, Budapest, and Prague, right?
Right.
Now, he further states in his second paragraph that it might actually take a while before they can perform repairs in Europe, in Eastern Europe. You see that?
Yeah, they already had these offices, but no repair sites at this time. This is right.
And he proposes using the offices instead as drop-off and distribution sites, right?
Right.
And he also proposes sending the machines to The Hague for the actual work.
This is correct, yes.
And you didn't tell any of that to the folks at Cranbrook, did you?
No, but the contract doesn't require to do so.
Doesn't the contract require you to disclose in writing the terms of any proposal?
As far as I recall, we sent them those terms. Oh, not the one you actually trying to point out, but we sent them the letter where we explicitly attached the offer from Contendo.
Right, and in that offer that you attached to Cranbrook, it doesn't mention anything about sending machines to The Hague, does it?
No, but that was not the plan. The plan is, I mentioned it, like in 2 years, they will have this repair sites. So I'm not sure if they are building them right now or not, but yeah, so.
So the plan was that Contendo had 2 years to create these repair sites, right?
I can't recall if we explicitly talked about this plan, but at this time, we talked about the repair sites, we talked about We talked about our wishes that we do want to have boots on the ground also in Eastern Europe. So there was no such plan or explicitly agreement I can recall.
Well, in the proposal that you sent to Cranbrook, the Contendo proposal, it doesn't say anything about sending repairs to The Hague, does it?
This is correct, yes.
Okay. And it doesn't say anything that Contendo has 2 years to create these repair sites, does it?
No, it does not.
And instead, Cranbrook has to do these repair sites immediately.
They have to offer it, yeah, this is correct,
Okay.
yes.
And you'd agree that that's very different than the agreement or the understanding you had with Contendo?
I won't use that word, but yeah, you may come to that impression. This is correct.
In fact, you wanted to give Contendo sufficient time so that they had a volume to develop to justify having these repair sites.
Yeah, but they already had those offices, and this was important for us. Yeah.
But not the repair sites, just these offices.
No, but they had people and desks in those countries.
Counsel, can we wrap this up?
Yes, Your Honor. Now, isn't it fair to say that Cranbrook exceeded this Contendo proposal in 2 ways, right?
No, I wouldn't use the word exceeded. They offered different terms, so we considered it a counteroffer.
Okay, well, did they offer to, isn't it fair to say they offered to do the production on a much quicker time frame?
I'm sorry, you have to repeat those questions.
Sure. Did they offer, isn't it true that they offered to do the production on a quicker time frame than Contendo?
This is true, yes.
And isn't it also true that they offered a higher percentage on the royalty?
Offered a lot, but we didn't believe in them at this point anymore.
But that's what they offered.
Yeah, but their right was, and that's what we explicitly mentioned in our letter, their right was to match this agreement or to exceed this agreement. We didn't talk about royalties or anything else. So, yes or no? Or
Well, let's make it simple. Contendo offered you 15%, right? Across the board.
This is correct, yes.
And Cranbrook offered you 18%
Yes.
in Eastern Europe and Scandinavia, right?
Yes.
And 15% everywhere else.
Yes.
And Contendo offered the repairs at The Hague, right?
Yes.
And Cranbrook offered repairs in a central location in Germany, right?
Yes.
Okay. And you still rejected their letter, Cranbrook's letter.
This is correct, yes.
And you waited until the 30th day to tell them you were rejecting their offer.
Yeah, after we told them before that they have 30 days. So,
Okay.
yes, but you're correct.
And in fact, Contendo never opened up those repair facilities in Eastern Europe, did they?
For the time being, no.
Okay. And you have not enforced your liquidated damages provision against Contendo, have you?
No, but they did a really good job, so to value this business relationship, this makes no sense, yes.
Okay. But you didn't enforce it, did you?
This is correct, yes.
Okay, thank you. That's the close of the evidence, I believe. The defense has rested. Okay, thank you very much. Counsel can now proceed with their closing arguments to the jury. We're getting very close now to giving this case to the jury. We'll just have the closing arguments, then I will instruct you on the law, and then it will be your case to determine. Is counsel for the plaintiff prepared to close to the jury?
Ladies and gentlemen, the evidence tells a compelling story of how Intellex broke its 2 promises to Cranbrook. First, it promised Cranbrook it would have an exclusive license to manufacture and distribute the smart plug product in Europe. But when the SP2 product came to the market, Intellex broke its promise to Cranbrook and entered into an exclusive license with another company, Contendo. Second, even if SP2 was a new and different product, it was still contractually obligated to offer Cranbrook the right of first refusal on that product. And instead of doing that and abiding by its obligations under the contract, the defendant conspired with another company to deprive Cranbrook of that right. Now, there's 3 issues for you to determine today. First, whether the SP2 product was a modification or an improvement of the smart plug product so that it was covered under the scope of the exclusive license. Second, whether Intellex offered Cranbrook its right of first refusal in good faith, and whether Cranbrook effectively exercised its right of first refusal. And finally, whether Cranbrook satisfied its obligations to exercise best efforts and its performance under the contract was satisfactory. Now, turning to the first issue, there is no dispute that the contract provided Cranbrook with an exclusive right to manufacture, sell, and distribute the smart plug product. And we saw that on slide 1, when we have the language of the contract and it talks about the exclusive license. Now, the question for you is whether SP2 is included in the definition of smart plug. If you look at the next slide, on paragraph 11B, it defines smart plug and smart plug products. Now let's take a close look at that definition. There are 3 key components of the definition of smart plug. First, that it includes products or devices that are based on the smart plug technology. Second, that it includes products that are designed to be used with the smart plug technology. And third, it includes all modifications, revisions, and improvements to that technology. So how do you know that SP2 is included within the definition of smart plug under this contract? Well, use your common sense. What did Intellex decide to name this product, which they now claim is a new product? It decided to call it Smart SP2 and previously Smart 2. Ask yourself, if SP2 was truly a new product, why did Intellex decide to call it Smart 2, or SP2 for that matter? Why did they use the same initials and the same words as smart plug? Isn't it more likely than not that SP2 means smart plug 2? Second, how do you know it's included in the definition of smart plug? Let's look at the next slide, and let's look at the Intellex witness's own words. Look at how Intellex's CEO and vice president described SP2. The CEO said it picks up and improves upon the process Intellex began with smart plug. Doesn't that sound like an improvement to you? And the Intellex vice president, Willa Judson, said that SP2 builds on the excellent technical base in smart plug. Smart plug is the base, SP2 builds on that base. And finally, the 2 products are compatible with each other so that each machine can run all of the products of the other. Doesn't that sound like the SP2 product is designed to be used with the smart plug product? Now, you might be wondering what to make of the fact that Intellex's CEO wanted to exclude the SP2 product from the scope of the license. And in fact, he specifically directed Ms. Judson to do so. Now, compare what he told her to do, which is on the, I think that's the left-hand column, and on the other side, look at what she actually did. He told her this product, SP2, has the potential to knock the socks off of anything in the market. It can run both action games and cerebral games, and it has the potential to dominate the worldwide market. And he told her, make sure you exclude this product in the license. But what does she do? She doesn't exclude it. She doesn't carve it out from the scope of the license. She stays silent. She doesn't tell Ms. Rosenberg anything about SP2. She doesn't tell anything about Smart 2. Instead, she assures her and she misleads her and she says, the license is a broad license. It covers not only smart plug, but any plug, and anything else for that matter. And she further misrepresents that there's no other product in anticipation of being introduced to the European market. And you saw the contract, you saw paragraph 11B. There is no mention of SP2, let alone Smart 2. And why didn't she do that? Why didn't Ms. Judson simply follow Mr. Morganfield's directions? Because she knew that Cranbrook wanted the right to have an exclusive license on any improvements and modifications. And she knew that if she mentioned SP2 or Smart 2, that they would ask for that to be included expressly in the definition. And the reason she didn't do that is because she knew that would not allow the deal to go forward. And if the deal didn't go forward, ladies and gentlemen, she would not have received her 15% raise that she had asked for. And her CEO told her that. Now, in addition to the exclusive license, you heard that Cranbrook also had a right of first refusal with regard to any or all new Intellex products not covered under the agreement. So even if you'd find that the SP2 was not an improvement or a modification, you still have to decide, was it covered under the right of first refusal? And did Intellex properly offer that right of first refusal to Cranbrook? Now, you heard from the CEO himself. He knew they had a right of first refusal. He acknowledges it today. And he also acknowledged that he tried to get them out of that right of first refusal. First, by offering them $100,000 to waive their right of first refusal. They weren't going to take that. That was not enough money. Second, he structured a deal he knew they would not be able to take. He conspired with another company, Contendo, to create these so-called services that he knew Cranbrook would not be able to provide. And these were those repair sites that we heard about in those 3 Eastern European countries. He also included a liquidated damages provision. Now, ask yourselves, is that really a good faith offer of a right of first refusal? But it gets worse, ladies and gentlemen. That was not it. He did not disclose the true terms of the deal to Cranbrook. He was obligated under the contract to provide written notice of the terms of any offer by a competitor company, and he did not do that. The proposal that he provided did not mention anything about repairs in The Hague. It did not mention anything about a 2-year time period to open up these repair offices. He hid the true terms of the proposal. So point 1, they didn't even notify Cranbrook of the terms of the proposal from Contendo. Now, how do you know that Cranbrook properly exercised its right of first refusal? Well, it first timely submitted its offer. It did so on June 3rd, even though it had until June 18th to inform Intellex that it had accepted the offer. It also exceeded the terms of Contendo's offer. It provided a higher royalty. Contendo provided 15%. Cranbrook provided 18% in Eastern Europe and Scandinavia, and 15% in the rest of Europe. It also exceeded the offer by agreeing to start production as early as October 1, 2016, whereas Contendo waited until January 1st, 2017. And both proposals were equivalent in the sense that repairs were mailed to The Hague under the Contendo proposal, and repairs were mailed to Germany in the Cranbrook proposal. Now, Intellex's lawyer will probably make a lot of the point that there were no liquidated damages until June of 2017. But how do you know that was not really a true material term of the proposal? It was a sham, ladies and gentlemen. And I submit to you it was a sham because when, to this date, as we sit here today, Contendo has not opened up a single repair site in those countries, and Intellex has not enforced its liquidated damages. So Intellex has not sought that $50,000 per month for each month that those repair offices have not been opened. Now, finally, their last desperate effort to get out of their obligations under the contract is to blame the victim. They're blaming Cranbrook. They're saying Cranbrook did not meet its end of the bargain. It didn't perform to our expectations. It had this UK marketing strategy instead of a European strategy. But look at the contract. Look at what the contract requires. It requires best efforts, and it requires satisfactory, substantial performance. Now, how do you know that Cranbrook's performance was satisfactory? Because Cranbrook told Intellex about its sales and market penetration figures. And when it did so, Intellex never complained, not once, not until they came to court today. And how else do you know? Because they told the press, they told Games and Toys that their performance, that Cranbrook's performance was outstanding. They didn't say it was not satisfactory. And even in the internal email that the CEO wrote to Ms. Judson, he described Cranbrook's performance as satisfactory. And how do you last know? Because they renewed the contract. They used Cranbrook for 5 years, and they had the right to renew the contract if the performance was satisfactory, and they did so. So they retained Cranbrook for another 5 years. And they make a lot of the fact that the sales of SP2 of SmartPlug were 0 in the later years. But does that really surprise you when SP2 comes out? The sales of SmartPlug are going to decline because now you've got a new product that does both action games and complex games. And so who's going to buy SmartPlug when they can go with SmartPlug 2? So ladies and gentlemen, you've heard today the evidence. You've seen how Intellex deprived Cranbrook of both of its rights under the contract, the right to the exclusive license, the right of first refusal, and don't let them get away with this. Hold them accountable for the promises that they make. This is how business should be done.
Thank you, Ms. Sheth. Mr. Madison, closing argument for the defense.
Yes, sir. Well, first, ladies and gentlemen, I want to, on behalf of Intellex and Mr. Morganfield and Ms. Judson, thank you very much. You've been very attentive. I've noticed you've taken notes, and we appreciate that, and I'm sure the plaintiff's attorney appreciates that, too. You know, we talked about broken promises in opening statement, and I agree with Ms. Sheth. I don't think she argued that in closing, because it's clear the broken promises were by Cranbrook. But the more you think about this case, it's really about a failing business. You know, we've seen the testimony that Cranbrook was losing money every year, year over year. And they were an anachronism, basically. They were an old-fashioned, traditional British toy company. And so they came up basically with 3 strategies to try to right the ship. First one was, remember, the consultant AMR comes in and says, we're going to make you guys into a gaming tech company. They have no experience in tech. They have no experience in video games. And they have no presence on the continent. And the consultant says, not to worry, we'll go get you an employee, come in, prop her up, and sort of like if anyone remembers the old phrase, Potemkin village, you know, they'll pretend that they've got this capability, and that'll be how you can save your company. SmartPlug is killing it in the United States, so this is the ticket out. So that's the first attempt. And I've created a timeline for us just so we can follow along the key events. So 2010, we heard Mr. Morganfield founds the company. 2011, Intellex rolls out the SmartPlug technology, and it succeeds overwhelmingly in the US. And so in early 2013, they begin negotiating for a European marketing effort and for a partner, a European partner, who could give them what they needed on the continent. And this was the March 4, 2003 letter, and there's just no dispute that Ms. Judson was crystal clear with Cranbrook and with Ms. Rosenberg about what Intellex needed. You've represented to us that you have the capability today to distribute all across Europe. If that's not the case, let us know and we'll find another licensee. And Ms. Rosenberg, and I appreciate her candor, said, I did make that representation. I told her that. And sure enough, after the agreement is signed in July 2013, and we have the agreement in evidence with all that it says, the specifications about Europe being so important, and not just part of Europe, but all of Europe. Let me go back to that. The term Europe is clearly defined as being all the countries. So how can anyone stand here and say that it was okay to sort of start in the UK and ramp up? And what does Mr. Nichols mean anyway when he says it would bleed over? Remember that testimony? We'll start in the UK and then it'll just sort of bleed over. Well, that's not the way modern business works. It's not just going to float in the air across the channel and saturate the continent. And they know that because Ms. Rosenberg told them that. The person that they brought in to sort of pretend to be the company that could do this, the first thing she says to them is, look, now that we've got the contract, we need a marketing effort. Now, she negotiated the contract, Ms. Rosenberg, on behalf of Cranbrook. She knows what best efforts means. I mean, you notice all this testimony and questioning about, well, you didn't specify what best efforts are. You didn't say how much advertising. You didn't say how many countries you had to cover. It's not necessary. They know. Look what she says. We've got to begin to pursue a marketing plan for sales on the continent. That's the whole tenor of this entire agreement. We're traditionally strong in the UK, but Intellex is depending on us to be equally strong in France, Belgium, Germany, Holland, Italy, and throughout the EU. She recommends 70% of their advertising budget, a multilingual campaign. And remember, she's multilingual. She spent time on the continent and doing everything they can to generate the kind of effort that they agreed to, the best efforts under the agreement. Now, Ms. Rosenberg, her proposal is rejected. This is the saturate the continent right from the start. She knew exactly what the contract required. And when Mr. Nichols rejects it a month later in November, and he sort of brushes her off in this very sort of Anglo-centric way, you know, you're our marketing director, but let's concentrate on the UK. And then they say, what's the British strategy? There was no British strategy. What are you talking about? It's the British strategy right there in black and white. That's what he's doing. And that's fine if you want to be a third generation British toy company. But that's not what we bargained for, and that's not what they promised us, and that's not what they contracted with us for. And you know, on some level, it's an old story, right? The first generation creates the fortune, the second generation builds it up, and the third generation runs it into the ground. And that's apparently what's happened with Cranbrook. Because again, we saw, and it's not disputed, they are losing money. Remember the memos that we saw internally where Mr. Nichols is telling his entire senior staff, this isn't good enough. We're losing money so fast, we're not even going to be able to keep the Intellex contract that we have now. We're not going to be able to perform. So Ms. Rosenberg, she votes with her feet, doesn't she? She leaves. She quits. And she writes a memo memorializing her resignation and why she did it. And again, I hope her parents aren't ill, and if they are, I hope they're fully recovered. But she doesn't talk about anything like that. She says, I do not believe I can take the Smart Plug project any further given your insistence on a British strategy. She knows what they agreed to. She negotiated it. She knows what best efforts are. She's proposed it. And he said no, and she said, well, game over. We can't perform. And she moves on. Now, she comes to court, and interesting that a company losing money hand over fist year over year offers $160,000 of stock to an employee who was there 2 years. And I submit to you, she's trying to earn that money with her testimony about, you know, these meanings of the contract that aren't spelled out in black and white. And of course, we've got that memo where Mr. Nichols said, we need you to say. You tell a witness, we need you to say. That is a clear subordination of testimony. And it's contrary to what the documents say, which is why he needed to do it in the first place. So then we come into this period where we announced the SP2, and this is where the second, remember I told you there were 3 attempts to save this dying company. First was prop up Ms. Rosenberg and try to get the European marketing for intellects. The second is try to get SP2. And they know they have no right to it, but they also know it's going to be extremely valuable. I mean, this is a creator and a company that is hot as can be. They know there's going to be tremendous value there. They're losing money year over year. Let's grab that SP2 and maybe we can sell the rights to someone else, or they'll buy us out, or we can take it and actually do something with it this time, and we'll save our company. And what's the first thing out of Mr. Nichols' mouth when he hears about SP2? Congratulations, that's great, and I hope someday you'll license that to us. Now, if you already own the license, why would you tell the licensor, I hope someday you'll license it? I mean, the actual language is, I look forward to the day that you license it, but it's crystal clear. They don't have the license to it, and they know they don't. But sometime between then and the later communications and developments and the lawsuit, they see this is our second opportunity to save the country, the company, excuse me. We're going to grab on to SP2. And, you know, the proof is in the financials. I mean, this is not a subjective pursuit. You know, you can look at the sales and know how they're doing. And we established in the testimony from both sides that, you know, over half, 18 or 19 countries out of the 28 in the European Union have zero sales. And Mr. Morganfield says, you know, with all modesty, my product is good. They like it. And if we promote it, there will be sales. And everywhere they've actually promoted it, there are major sales. If you look at Great Britain.
Let's move along.
Yes, Your Honor. If you look at Great Britain, they're doing excellent sales in Great Britain, which also explains the renewal of the contract. Is, you know, the opportunity to hit the market hard for smart plug, that's long gone. It's already been out there for 5 years. Cranbrook was performing well in Great Britain, and so they renewed the contract. But no good deed goes unpunished. You know, they want more, more, more. And of course, the irony is they're saying that for their right of first refusal, we offered more. We offered 18%. Well, you know where they offered the 18%? For Eastern Europe and Scandinavia, where they've never had $1, €1, £1 of sales. So they could offer 18%, they could offer 180%. They're just trying to do everything they can to grab onto this value that doesn't belong to them. And that's the final attempt to save the company. You know, they tried to get the smart plug when they really weren't able to perform. They tried to get SP2 when they did not have a legal right to it. You know, on the one hand, they say it's already ours under the license. On the other hand, we get a right of first refusal. The truth is neither. And so the third attempt is right here in this room. They're hoping that you will award them tremendous value and allow them to somehow save the company. And in all good conscience, you just can't do that. I mean, what is Mr. Morganfield to do if they have SP2? Just accept the fact that in 18 or 19 out of the EU's countries, he'll never see a single sale because they won't promote it? That's not what the parties agreed to. You know, one thing about jury duty is, jury service is, you don't check your common sense at the door. His Honor will instruct you on the law, but you also use your reason and your common sense. And everything about this case tells you that the only verdict you can enter is one on behalf of intellects. So I've provided you with the jury verdict form that you will receive. And not that you need the help from me, but
Thank you, Mr. Madison.
those are the two answers that you should put.
Thank you, Mr. Madison.
Thank you, Your Honor.
All right.
Your Honor, can we have one moment with you at sidebar before you read it? It's important.
I will. That's fine. What do you mean? Already argued. Let's do this. Okay, ladies and gentlemen of the jury, you've heard the evidence and the arguments of counsel. I will now instruct you as to the claims and defenses of each party and the law governing the case. You must arrive at your verdict by applying the law as I now instruct you to the facts as you find them to be. On July 15, 2013, the plaintiff, Cranbrook Industries, PLC, and the defendant, Intellex Electronics, entered into a licensing agreement for the sale and distribution of smart plug video games in the United Kingdom and Europe. In 2012, Intellex entered into a contract with Nintendo Gazelle NV for the sale and distribution of SP2 video games in the United Kingdom and Europe. Both sides agree that these contracts existed. It is the terms of the contract between Cranbrook and Intellex that give rise to this dispute. Plaintiff Cranbrook Industries claims that it was contractually entitled to the licensing rights to the SP2 video gaming system and that Intellex's arrangement with Nintendo Gazelle NV violated Cranbrook's contractual rights. Cranbrook asserts two grounds for this claim. First, it is Cranbrook's contention that the SP2 video games are a modification or improvement of SmartPlug and are therefore covered under the contract between Cranbrook and Intellex of July 15, 2015. Second, Cranbrook also contends that the contract of July 15, 2015 gave Cranbrook a right of first refusal for the European licensing of any and all Intellex products, and that Cranbrook exercised this right by timely presenting the necessary writing to Intellex. Intellex denies that it breached the contract in any way. Intellex also denies that SP2 is a modification or improvement of SmartPlug, and therefore denies that SP2 was covered under the contract of July 15, 2013. Intellex agrees that Cranbrook was entitled to a right of first refusal on the European distribution rights of all Intellex products, but claims that Cranbrook failed to effectively exercise that right in a timely fashion. In order to find that SP2 is a modification or improvement of SmartPlug, you must find that SP2 is the sort of advancement in technology or production of SmartPlug that was contemplated by Cranbrook and Intellex as a modification or improvement of SmartPlug when they entered into the contract of July 15, 2013. To find that Cranbrook effectively exercised its right of first refusal, you must find each of the following. 1, that Cranbrook tendered to Intellex a written acceptance that met or exceeded the material terms of the proposed contract between Intellex and Nintendo Gazelle NV. 2, that Cranbrook's written acceptance did not constitute a counteroffer. And 3, that Cranbrook tendered its written acceptance in a timely fashion. Intellex claims that Cranbrook had a contractual duty to use best efforts to market the SmartPlug video products in Europe as defined by the contract. Intellex claims that Cranbrook did not use best efforts and, as a result, breached the contract and was not legally entitled to exercise the right of first refusal on SP2 products or to any renewal of the July 15, 2013 contract. If you find by a preponderance of the evidence that Cranbrook did not perform its obligations, Cranbrook cannot claim a breach of contract by Intellex. If you find by a preponderance of the evidence that Cranbrook has established either of its claims, then your verdict should be for the plaintiff, Cranbrook Industries, PLC. If you find that any of Cranbrook's claims are not supported by a preponderance of the evidence, then your verdict should be for the defendant, Intellex Electronics Incorporated, on those claims. So, at this point, if this were a trial, the jurors would be sworn. They would retire to a deliberation room where the first thing they would do would be to elect one person, the foreperson, who would be in charge of communicating with the court. They send out notes through the bailiff. They would deliberate until they reach a verdict. If they can do it in a half hour or 15 minutes, I mean, that would be miraculously fast. That can theoretically can happen. Or it can take a few days in a major case where there's been lots of evidence and they've been there a long time and there are things to discuss. It can take a few days for a jury to reach a verdict. I would say usually for a case like this, they would be out for at least a few hours, might come back the next day and deliberate for a while. It depends on, really how much there is to discuss and where they are. But our experience is we get to talk to the jurors afterwards and find out how did you reach your decision, what was important to you. And it does happen, the jurors change their mind. They may take an initial vote, but the give and take among the jurors will cause people to rethink their initial positions. Because it's kind of a remarkable thing, and I bet we'll see some of this here. People pick up and remember different things, and so that's part of the power of the jury. You've been force-fed a lot of material in a few hours this afternoon, and I'll bet different things registered with each of you, and that all comes out as part of the deliberation. So I'd like you now, just if you in front of everyone, we won't ask you to elect a foreman, but we'd kind of like to hear a discussion amongst you about what you think, and like to hear responses from others of you to those thoughts. Would anybody care to begin? There's a microphone there in front of you. There's more than one mic. There you go.
Trud.
There you go. Yeah, what are your thoughts on the issues that have been presented? Basically, did Cranbrook perform under the contract? Was the SP2 part of the original license? Did they effectively exercise the right of first refusal? I think those are the three main questions.
Actually, I think that SP...
Can everybody hear? Can you hear?
Actually, I think that SP2 is a modification of the original, what was it, smart plug.
Right.
And nevertheless, there is a contract. And in the contract, it says modification, then the other things are covered. I think it's kind of stupid the way the marketing strategy is of Cranbrook, when you think he only wants to distribute it in the United Kingdom. And I can understand the intellects that they get mad and that they want to have. I mean, everybody knows how fast the computer market is, right? So if he starts distributing only in the UK, they never sell somewhere else. And it's easy to offer 18% to give them from countries they never sold a single device, okay? So that is what I think.
So if I understand what you're saying, you think that the device, the SP2, would be covered by the original license because
Yes.
it's a modification, it fits
Yes.
the language. You don't think Cranbrook performed, its marketing strategy was not best efforts,
No.
and you think they did not properly exercise the right of first refusal. Is that right?
Yes,
Okay.
that's right.
Any reactions from anyone else?
If I was the one to declare my opinion, so I would...
You are the one.
Okay. So I would put one remark ahead. So first of all, I'm not a technical expert, so I cannot judge all these technical details behind these products and technologies. So I can only have this common sense and convey this common sense. So to me, my one key learning is that Intellex was on search for a business partner, and they took the wrong choice. They found the wrong bride, and afterwards they were disappointed, and they tried to get rid of their partner, of their bride. So
It happens.
Pardon?
It happens.
Yeah. Yes. Yeah. Okay. So another thing, and I think that the methods are not really appropriate. First of all, if I have a business partner, I try to talk to each other. So obviously they did not. Because if there is a failure in marketing, in sales, in whatever, I talk to each other, and there is a notification, there is facts, there's meetings where you put all these on the desk. So obviously that did not take place here. So it was more an atmosphere of distrust, no exchange, no constructive manner, and I think that Intellex would be in the position to reject the so-called British marketing strategy, which is no strategy, but they would have had the opportunity. So another thing about the technology, and it's, to me, it's a semantic discussion about improvement and modification and technology and whatever. So even if it was a next stage technology, it does not, you cannot, Intellex cannot ignore the sense of the contract. And in my understanding, they did. And so I have a clear opinion for that, and that means, yes, the contract has been breached twice.
Okay. So, I mean, you share the opinion of the first juror that SB2 came within the definition. So it was part of the original license.
Yes, yeah, that's my opinion, and so this is supported also by the product naming. So SB2 suggests that there is a very strong relation to the other products. So
how about the right of first refusal? Was that properly exercised?
Properly, I don't know which is really properly. I think that that the promises that are part of this letter are not really convincing. So the other thing is it formally correct? And as far as I can judge, it's formally okay. I would accept it.
I'm sorry, so they did properly exercise? You think they did exercise the right of first refusal?
What means exercise? If they made this refusal, letter of refusal, what is the term?
Right of first refusal.
In time.
And they accepted it in time.
Yeah.
Okay.
So that's. I'm not talking about the content and the promises.
Right. No, I understand.
Just about the timeline.
All right.
Yeah.
Any reactions by other jurors?
Yeah, I would agree concerning the point that it's a further development or improvement of the original product. So it's included in the license agreement. So that's the first point. Second point concerning the right of first refusal. Like was this, it wasn't 100% clear, but I would also say that was proceeded correctly on time and matched or exceeded the content of the competition based on the information the party had. There were some things, I mean, if it was hidden or not, other information, it doesn't matter in this case because concerning the information which you seem to have, they matched or exceeded. And what the third point was, counter offer. First, no, there was a third one, but I'm not sure.
Well, whether they marketing,
the marketing,
whether they fulfilled their marketing obligation.
They are not great performer, and I would kill them if they were my business partners. But concerning concrete contract agreements, they didn't breach it, in my opinion, because it was not clear. So if there was the concrete number, market shares, or numbers, so. You can discuss what it means, what it's satisfactory, but for them, they can say it was satisfactory and they can say no, but it's a feeling or something. So as it was not clear, that's okay for me as well.
Okay. Mm-hmm. Anyone else?
Hi, hello. I think the first problem of all was the leak of conversation. They're just writing emails and doing stuff, but there was no conversation on the telephones or, you know, when you have a business partner, you have to talk every day or every week or even much more. And the other thing is like, T told us the SP2 is a complete new product, but it's not possible because SP and Smart Plug 2, it's like, you know.
The names are close.
The name is too close, it's too obviously that's the same thing.
Mm-hmm.
But on the other hand, Cranbrook's, I mean, if you tell somebody you will make the business in whole Europe, it's whole Europe.
Mm-hmm.
So there's no country missing, not even the furthest one up north.
Mm-hmm.
So they did not do a good job.
It didn't, okay.
Whole Europe is whole Europe. It doesn't matter if it's out of the UK or it has
Brexit
to be,
or no Brexit, they didn't do what they agreed to do. Okay, how about, we haven't heard from two of you.
By the way,
Yeah.
if I was the CEO of Intellex, I would fire the man who worked out the contract, because it's so bubbly and blurry, and there is no concrete figures.
Well, yeah, she was very clear she wanted to get her bonus, her increase.
To me, this is not a very good contract. No.
Okay.
No clear targets.
Right.
Okay, so I agree to some points, but I think that Cranbrook didn't perform, and now they try to get the best out of it, and it's just my feeling. So I think that Intellex is not guilty.
Mm. Okay.
But I also agree to the points. I think I would need some more time to think about it.
Okay. I mean, actually, the way this works is if the jury concluded that Cranbrook breached the contract materially and had not performed, you would not even get to the other questions. Because if they breached the contract in a material way by not performing, then Intellex would be entitled to terminate the contract, not give them SP2. They wouldn't be entitled to the right of first refusal. So that's kind of an initial question. That would have been a showstopper, we'd say.
Sure.
Did they?
Huh?
Did they breach the contract by not?
It's up to you. You know, that we have jurors, that's what we have jurors for. We put that question to the jury. Do you regard, under all the facts and the law, do you think they materially breached the contract? They would get that.
The audience.
We will. We have one last gentleman, and then I want to hear what the audience thinks.
Okay, I think Intellex don't breach the contract because SP2 is a complete different technology to SP. Okay, that the name is almost the same, but I think he explained it good that it's a complete different technology, and so it's almost not the same. So they don't breach the contract. And to Cranbrook, I think the performance was really bad. So in half of Europe, you don't sell anything. And yeah, I think the same that when you have a partner, so you have to speak and weekly or daily. Sonst it makes no sense.
Okay.
Yeah.
Well, let's see by a show of hands in the audience. Let me first ask if you believe that Cranbrook materially breached the contract by failing to perform its marketing obligations. Please raise your hand. So I'm seeing it's about split, maybe a minority. A minority thinks that was a material breach. Okay, let's go to the next question. How many, raise your hand if you believe that the SP2 was covered by the original license because it was just a modification or an improvement, etc. Clearly a majority. How many believe that, raise your hand if you believe that Cranbrook effectively exercised the right of first refusal? That's interesting. That's a minority, distinct minority. But if you all were the jury, you would have found no material breach by Cranbrook. You would have found for Cranbrook on the license issue was covered by the original license. So the fact that you found against Cranbrook on the right of first refusal wouldn't matter. So this is very interesting. And this is, you know, so people, if this was a real jury, you'd get together and have an exchange of views, and I'm sure you'd see that different people remember different things. It's very rare for a jury actually to get deadlocked. It can happen. If that happens, judges hate it because the system has an investment in getting this over with. Because what happens if the jury can't reach a conclusion, then you have to retry the case. It's called a mistrial. You start over again. Not with the same jury. It'll be a couple of months down the road at least. Well, let me first thank our fantastic jurors who paid attention and shared their views with us. Thank you very much. And our witnesses who also did a fine job. We're going to look for other trials for them to participate in. And thank all of you for coming. We enjoyed doing this program for you very much. Thank you.